May please. Right back to item number 3. Yes.
May I please, Your Lordship? Your Lordship, I beg to mention item number 3.
As for orders, madam, let the matter be called out. Let's see what the matter is listed for.
Your Lordship, the senior counsel is indisposed.
We understand. Just let us see what is the matter listed for. If it is for a formal kind of order, let's do that. Unless unnecessary files get rotated. Orders cases you need not get adjourned without any reason. Let the matter be called out. Wait, we will not pass any adverse order. Okay.
Obliged, Your Lordship.
My lord, in item number 1, my lord, as such, I have got any instruction, but I assume that they are not keeping connection with me. They have lost interest perhaps.
So we should dispose of the appeal.
Yes, ma'am.
And counsel, Mr.
M.H. Rajbur, ma'am.
M.H. Rajbur submits that the appellant is no longer in touch with him and seems to have lost interest in prosecuting this appeal. Accordingly, the instant MAT number so and so and all pending applications are disposed of for want of prosecution.
Obliged.
Wait, please, Your Lordships. I beg to mention item 7 of today's list. My lord, respondent number 2 is personally present in this court in terms of the last direction of this honorable court.
Please.
He has filed his affidavit this morning. If I may be permitted to bring it. Deeply obliged.
Let the affidavit be called.
Obliged, Lordship.
My lord, item number 14 may be passed over for the day, my lord. For 1 week, my lord. This bail in criminal appeal.
You are appealing for?
Appeal, my lord.
Why do you want to pass over?
My lord, some information, my lord.
What information, sir? The information is there on the record.
Yes.
Nothing new is going to come. This is an appeal.
This is from jail only, my lord.
What he will do? From jail, he can't send you money.
My lordship will take up.
Let the matter be called out. Let's see. If there's a pressing need to adjourn, we'll do that.
My lord, I beg to mention that number 25. My seniority is out of session, my lord.
Yes.
this
And
will-
counsel, Mr. So and so submits that the arguing counsel, Mr. Kakoti,
Akokati.
is not available today, and thus an adjournment is sought. List after 2 weeks.
Yes. Right.
No, 32 is left.
Yes,
May I
32.
please, Your Lordship? This matter, I will seek 4 weeks time to file my reply. With the consent of the other side, I would like.
And counsel Ms. D. Ghosh,
Yes, Lordship.
praise for it is granted 4 weeks time to file affidavit, rejoinder affidavit on behalf of the petitioners. List up 4 weeks.
Deeply.
Item 34, my lord. This matter may kindly be listed on Tuesday, that is on 16/5.
Why?
Because, my lord, there are some confusion regarding the land acquisition act 1894 and 2007.
So we'll remove,
So
we'll do away with the confusions.
No,
Are
no,
the matter.
that I could not go through all this.
And counsel, Mr. Mahmood, praise for time. List after 2 weeks.
Obliged.
I make a 37.
Yes.
Yesterday we filed a affidavit in opposition. Kindly make a record.
All right, bring the affidavit to the court. Yes.
Item number 2 of daily list for order.
My pleasure, Lordship. My lord, in this case, my lord, I want 2 weeks time to file objection. On the
Objection
application filed by-
regarding what? Objection regarding what, sir?
For the application has been filed by for grant of leave to file read appeal, my.
So you want to file an objection against that?
Yes, my lord.
What do you say, sir? Then,
Hello,
tell
it's up
Mr.
to you. Up to
Your
you,
good
lord.
name, please.
P.B. Majumdar.
PV Majumdar. Appearing for the
Response number 1. no?
respondent number 1.
My lord.
Praise warrant is granted 2 weeks time so as to file an objection in the IA number 445.
Yes, yes.
445.
Yes, yes.
List of 2
Obliged.
weeks.
Thank you.
Item number 3.
Mm. Yes, what is it about?
Your lordship, it's in,
Let us see what is the matter listed for. It's only we want to know. Orders cases, if there's something issue of service or something like that, at least we can have a look at it now.
your lordship, APSC had to file an affidavit.
Let us see, or its relation to some answer keys of an exam conducted long back. Latest answer keys. Cutoff marks on the basis of same. Selection process must have been completed long back. Revised answer key you are asking for. In the meantime, the main results have been published. Candidates have been selected. What remains in your appeal? Those candidates are not before us.
Your lordship may pass over the matter for the time being.
Oh,
Some
yes.
other counsel may appear
Yes,
after some time, your lordship.
yes, yes. And call Mr. Mahanta for APSC. Let's have the information. What is the status of the recruitment?
Lordship, candidates have been appointed, lordship.
Appointed,
And
yes.
few of the candidates are still to be appointed because some cases pending, lordship.
All right. Call Mr. Mahanta, we'll make an inquiry.
Lordship.
Matter number 4,
Contempt. No steps. Despite observation of this court in order dated 6/9/2021 that the alleged contemners have not been made party by name, comma, no steps have been taken in this contempt case till date. It seems that the petitioner is not desirous, not serious enough in prosecuting this contempt petition, as the same is dismissed for want of prosecution.
matter number 5,
We understand. What is it? for?
Respondents were required to file an objection to
Mhm.
our prayer for
Lordship, we
condemnation.
kindly
of delay.
grant us some few weeks' time to file the same.
Objection against?
Their condemnation of delay, prayer for condemnation of delay.
How many days is the delay?
557 days.
Okay, then counsel for the respondent place for hearing is granted. Last opportunity so as to file objection in the application for condonation of delay. Against the prayer for condonation of delay.
Obliged, madam.
List up to 4 weeks.
matter number 6,
In this case, I am appearing for respondent number 10 and 11. The appellants have also filed a suit. So I would like to bring the plaint, my lord, on record. Let it come up next week, my lord, so that I can
file the, my lord, affidavit.
Mr. Bidi Das, senior advocate representing the response numbers 10 and 11 submits that the appellants have
File the
filed
suit.
a suit in relation to the same subject matter
No, seeking relief, similar relief.
in seeking suit before the civil court, seeking identical relief as has been sought for in this appeal. He prays for some time to bring these facts on the list up 2 weeks as per it.
Number 7 to 9.
Well, in item number 7, my lord, the affidavit is on its way. My lord, if it may please be taken up at the end of the orders matters.
All right. What is it about?
This matter is regarding lordship, the removal and resignation of a president of a Jilla Parishad, lordship.
Okay.
So the case was that
You are appearing on behalf of?
I am appearing on behalf of the state of Assam. We preferred the appeal. And it was admitted, status quo order was issued, and lordship was issued a direction for a personal appearance of the deputy commissioner concerned
Mhm.
because he was not responding to the notice of the contempt.
Oh,
So he has appeared today, I think.
Is it-
And
okay.
he could not appear because he came to me yesterday that he for the first time, he is facing a contempt proceeding. He sent a response to the registry. So now a proper affidavit is being filed, lordship.
My lord, today the contempt is listed. So your, my lord, rest on a very short campus. So lordship may take up the contempt today.
We'll take up, we'll
Madam.
take it up. What about that e-processing? The direction given to provide email addresses of all your officers. These situations will be avoided.
Lordship, we have had a meeting and now everything is in process.
There should be a portal actually.
There is a portal, we are going to do that, and also we are digitalizing the Advocate General's office, Public Prosecutor's office, as well as the Senior Government's office.
Excellent. Probably you will take Assam to the leaderboard in the country if you are able to do that.
We are
Yes.
already the process is on, lordship.
Okay.
Along with that, the email, the nodal officers,
Make a portal on which
portal, yes,
the things are filed and they immediately reach the concerned official.
we'll do that, Lord.
As well as the Advocate General or the government advocate concerned. Okay. What is this? Affidavit has come.
My lord.
Then your lordship may take up, my lord.
All right.
Lord, the contempt is.
Who is
before
for the petitioner?
my lord, since the contempt is listed, I am for the petitioner, my lord.
Okay.
Yes, my lord, if your lordship comes to the contempt petition, my lord, the order which is, my lord, alleged to have been violated.
Yes.
That starts, my lord, from page, my lord, 15. I take your lordships to the relevant part. My lord, is at page 33, para 20, my lord. In fact, before reading para 20, my lord, the issue is, my lord, in fact, I had tendered my resignation. And in
Resignation from,
from the president of Jilla Parishad.
okay.
There is a statutory prescription. If I withdraw it, my lord, within 15 days
Mhm.
from its expiry,
Mhm.
then I will continue, my lord.
Okay.
So therefore, my lord, in fact, the respondents, my lord, they took the view that since, my lord, my withdrawal has been received by them after my period of 15 days,
Mhm.
so therefore I am deemed to have, my lord, vacated the office. So
Mhm.
this was the controversy, my lord. Now, if your lordship comes to page para 20, my lord, it reads as follows. The upshot of the above discussion is that in view of sending of the letter of withdrawal of resignation by the petitioner within the prescribed period of time as stipulated in section 72(1) of the Assam Panchayat Act, the office of the president of Karimganj Jilla Parishad cannot be deemed to have been vacated by the petitioner on and from the 16th day from the date of submission of his letter of withdrawal on 18/9/21.
Okay.
In view of reacting at the aforesaid finding, the letter bearing so-and-so dated 15/10/21 of the respondent number 3, the letter bearing so-and-so dated 11/10/21 of the respondent number 1, the letter bearing so-and-so dated 19/10/21 of the respondent number 3, the letter bearing so-and-so dated 19/10/21 of the respondent number 4,
Mm.
the sale in these two petitions are held to be incongruent to the provisions contained in 17(1) of the Assam Panchayat Act, and as such, the same are liable to be set aside and quashed. It is accordingly ordered. Now, this is my lord important.
Hmm.
Resultantly, the two petitions are allowed. As a corollary, the petitioner is deemed to have continued as the holder of the office of President Karimganj Jilla Parishad, notwithstanding the letter of resignation dated 18/9/21. Then the subsequent, my lord, direction at para 24, page 35 is also relevant. Your lordship may kindly come to 35, page 35.
Yes.
Para 24, until the special meeting to discuss the no confidence motion against the petitioner is held and the no confidence motion is decided, the petitioner will continue to function as the president of Karimganj Jilla Parishad, discharging its day-to-day function, but he shall not take any major decision in respect of financial matters.
Where is the contender, by the way? Where is the contemptor? Why is he sitting there? He is to stand here. Have you come for a stroll in the High Court or what? Yes.
Now, despite, my lord, there is a specific, my lord, direction
Mhm.
that I am deemed to have continued the office, my lord. Now they are not allowing me to function. The respondent number 4, your lordship will come to the writ appeal. This order is not part of the contempt. Writ appeal, my lord, 289/22.
Rupam, writ appeal.
289.
289/22.
Hmm.
Page 93, my lord.
Hmm.
Now, this is the order of the chief executive officer by which, my lord, if your lordship takes up, my lord, take note of the order 1910/21,
93.
1910/21, my lord,
Hmm.
page
Hmm.
93,
Yes.
his number, my lord, last number 1047.
Hmm.
Now, by this order, the respondent 4, he has, my lord, she was allowed to, my lord, discharge the, my lord, function as in charge president. Now,
Respondent
your
number 4.
lordship will kindly see, interestingly, this order has been set aside by the honorable single judge at page, my lord, 33 of the contempt.
You read, yes.
Yes. Now, meaning thereby, my lord, this order, pursuant to the honorable single judge order, my lord, this does not exist at all.
Hmm.
Now, they are saying, my lord, pursuant to this order, the private respondent 4 is continuing. Therefore, my lord, I could not be handed over the charge. My lord, there is a clear violation of the,
When was the stay order passed by the division bench?
my lord, the division bench, my lord, had passed a status quo order. My lord, only status quo, my lord. Status quo order was passed, my lord, on 8/9/22 in IA, my lord, 2764/22.
8/9/22.
22.
And when did you go and provide the copy of this order?
Yes, there is.
That is in the contempt petition, my lord.
And otherwise also the government advocate was here. Yes.
And in fact, my lord, the department was represented by the standing council,
Yes.
and they are aware of this order of the honorable single judge, my lord.
And what does the affidavit indicate? Affidavit filed today?
Yes. If your lordship comes to the, my lord, page 46 of the affidavit, para 7, it starts from para 7, my lord. That with regard to the statements made in para 6 of the petition, I say the letter dated 19/9/22 appearing at Annexer F, page 43 of the petition, being a letter addressed by respondent number 4 to the Commissioner and Secretary Panchayat and Rural Development Department.
19/9/22.
22. Much later, my lord.
Yes. Madam. Will you be arguing on sentence or what?
Beg your lordship's pardon.
Will you be arguing on sentence or what? This is gross disobedience of this court's order. The officer thinks himself to above the court or what? He's referring, you are referring to order dated 19/9/22, a year later.
My lord, the order, my lord, the honorable single judge, my lord, that came to be passed on 18/8/22, my lord.
Yes. And what after that?
After that, my lord, the process was initiated and it could not be completed, my lord,
How
within 20 days.
Or have been
But he received,
madam. Why was this man not allowed to join?
my lord, there's an order passed by the, there's a letter passed by the principal secretary, which says that she will, the respondent number 4 will in
All right, let us see the letter then.
my lord, page 50 of your lordship.
Okay, 11th October 21.
My
That
lord.
letter has been quashed presumably
Yes, my
by
lord.
the state court. And you are relying on that in the affidavit. That's another act of contempt.
No, my lord, that was prior to
Affidavit also
the,
bears
much
your signatures.
prior,
Madam, the affidavit also bears your signatures.
my lord, it does.
So partly you are also responsible. If you rely upon an order which has been quashed in response to a contempt notice, you can very well understand. All right, then argue why he should not be held guilty. Argue.
My lord, actually, my lord,
What more willful disobedience do we expect now? It's a clear order. All orders have been quashed. He is required to be taken on board as chairperson.
yes, my lord, that
Status quo order comes to be passed much later.
20 days after the honorable single judges.
How could would have been continued even a day after this court quashed the orders? All right. You are not representing contemptor, we hope.
But the facts, lordship, are not placed properly. That's why.
Sir, either you come and step into the shoes.
I'm not in the contempt because The state has filed the appeal. So
Whatever,
if-
sir, whatever, we'll see
Our
state's
lordship will
appeal.
have to know the exact facts. The facts are not placed.
We don't know, sir.
That's why I want to
Chief
place it. It's also
representative.
allowed because our appeal is also tagged with it.
Yes, you come, all right.
So they have challenged the original thing, but in between page 84 and page 50. Page 84
Of,
of the writ appeal filed by us.
yes,
Sorry, filed by Bimola. Where is it? There are two appeals. One is 291. I just got this order.
appeal filed by,
Appeal filed by Bimola. Suklabhai.
she is the respondent number 4.
I,
presumably.
yes, Lordship.
To
But
whom the
states
charge has
appeal-
been given.
This document is available in the states also, page 84.
Which appeal do you want us to refer, Mr. Sakia?
Lordship, 291 of 2022,
Page number,
page number 84.
yes,
So this order was passed by the principal secretary on 11th October 2021.
yes, that is the order she has filed along with the affidavit, 11th October 21.
This was not set aside, no. This was not set aside.
Read the order, sir.
With reference to our letter dated so and so, I have the honor to inform you that the resignation of Ashish Nath, President, is hereby accepted as per provision of 72.1 as amended. Further, the Vice President of Karimganj Jilla Parishad is hereby entrusted with the responsibility vested upon him under section 72(2) of the Assam Panchayat Act to act as the President in charge of Karimganj Jilla Parishad on temporary basis until further orders. Now, Lordship will kindly come to page
Just
86.
hold on, sir. Hold on, sir. Hold on.
Page 86.
Just hold on for a moment. This is letter dated 11/10.
Now, Lordship will kindly come to,
Sir, come to para 20 of the impugned order, please.
no, Lordship, only one page, page 86. Submission of joining report along with oath of affirmation of Bimola Suklabedya so and so.
Yes.
I have the honor to subject above. I have the honor to inform you that the Sri Bimola Suklabedya, now acting as Vice President of Karimganj Jilla, has submitted joining report dated 19/10/2021 afternoon to this office as Incharge President Karimganj Jilla Parishad as per instruction mentioned above. The oath of affirmation signed by Bimola Suklabedya is enclosed herewith for favor for your kind perusal. So now, assuming that all these are set aside.
There is no question of assuming, Mr. Advocate General. There are specific quashing of these orders in
Yes,
para
Lordship,
20.
but what right we have as a state? Can we not file the appeal within 30 days?
Yes, you have.
We have filed immediately. There was no delay.
Status quo order, sir. It is not an order staying the order of this court. By that, by twisting the meaning of that order, you.
Absolutely, Lordship is correct, but that stay order
No,
was,
sir, this is not tolerated, Mr. Advocate General. Plain and simple, we are telling you.
when the.
We will not tolerate this kind of insubordination by the officers.
No, insubordination, I also don't agree, Lordship.
So we'll not tolerate it. This is nothing, you are trying to play with the words.
But
We are-
when the appeal was admitted, Lordship, on that day,
You are representing contempt, all right, I argue on
no,
that.
I'm not on contempt.
Then all right, then you take your seat then.
Lord.
Yes, madam, come. We'll hold them guilty and send him behind bars right now. How do you justify then? Now, the order dated 11/10/21, you have filed along with your affidavit, which has been quashed.
Yes, my lord, on 8/9/20, on 18/8/22.
Yes, and this affidavit is filed today.
Yes, my lord, he could not, my lord, what had happened was he had received the papers of this honorable court and there mistakenly it was addressed to the registry, my lord, that he.
Madam, what he has done to comply with this court's order till date? The order was to be complied with forthwith. There was a 20 days gap in between before the status quo order came to be passed. What was done to comply with this court's order?
That he had come in yesterday, my lord, I'll obtain the details, my lord, what action he had taken.
He was there when this 18/8/22, was he there or not?
He was there, my lord.
And the department was represented.
Department was represented. my lord.
All right, tomorrow.
Applied.
And will not take up the appeals before the contempt is decided. Your officials have to have to understand that this court's orders are to be complied with, come what may. Is that clear directions. Orders are quashed, he has to be placed back.
Lordship, I'm just.
How can he play with this court's orders in this manner? Yes, please.
Lordship, I'm appearing for respondent number 4, Lordship.
Yes.
Right now, I am holding the post of President in service. Lordship.
All right.
My
What do you say?
Only submission was that, Lordship, the order was passed by the learned single judge on 18/8/2022, Lord.
Yes.
And the status quo order was issued on 8/9/2022.
Yes. So for even a single day, respondent number 4 could not have continued in office thereafter.
And the contempt case was filed on 12/12/2022, Lord.
Irrespective, sir, what about those 20 days? The order was there, passed in presence of the government advocate. It had to be complied with immediately. Filing of complaint is not very relevant in this case.
Yes, Lord. I'm just submitting the dates also. That's nothing.
We are asking you, was filing of contempt very relevant in view of the positive direction of this court that he shall be put back in office?
One further submission I would like to make. When the
Yes.
status quo order was passed, Lordship, on that the honorable court came to know that the earlier one was still continuing. That is why the stay order was not granted. Say that status quo should be maintained.
We are not
That was-
bothered, sir. We are not bothered. Saikia,
Otherwise, the case, the order would have been stayed on that day.
press the court, please
No.
pass. And
It was on the other side. The other side was all, till that moment, the contempt case was also not filed.
yes,
The honorable division bench on that day was about to pass a stay order.
Ms. Saikia, is this court supposed to act in executing court?
No, absolutely.
The order is passed. Your officers have to realize that it has to be complied
Lordship, At
immediately.
least the normal understanding is, Lordship,
Yes,
that at least we get 30 days. If we either we comply with the order, we challenge it.
We
What
would
is the
have-
normal course.
we
Lord?
would have agreed if there was an absolute stay on the order.
That stay order was not granted because till that moment, the contempt was not there. Contempt was passed 2 months later, number one, and number two, Lordship may not accept my submission, but
Yes,
the other part was that as because the private respondent was still continuing, the honorable court said, let him continue. That is why we are passing the stay order.
is that recorded in this court's order?
The bench has changed. That is the problem.
Is it recorded in the order of status quo that the respondent is taken charge?
Yeah, because our whole submission was on that.
The order, let's read the
Yes.
status quo order. If that is so, yes, things would have a different perspective. Let's see.
That is what, Lordship. I do not lie before any honorable court.
There's no question of lying. We are asking you whether it is recorded in the order.
It was a very short order, but let me place out.
Yes,
8-9.
yes,
Heard D. Das, Senior Counsel for and P. Nayak, and D. Sakia for the state. Notice returnable so and so. JMA Chaudhary Learned Counsel appears so and so, all this. Meanwhile, status quo to be maintained by all sides.
yes,
The state is directed to produce the original records in a sealed cover before the registry of this court within a period of 2 days.
yes, yes.
More particular relating to LS resignation letter dated 18/9/2021,
All right,
along
just
with the
hold on.
file.
When did you go to the officer with the order? That
Yes,
please
my lord, this is
give
part
me
of
the charge.
This is part of the contempt application.
See that.
Your lordship will,
That.
yes,
Read that.
yes, my lord.
Whether you, if you file the particular application, let us see.
Yes.
Where is it?
Your lordship will come to page 36. It has been received, my lord.
36.
20, no? 20, yes. 28.
This is to the principal secretary. My lord, this is received under seal and signature. It is
Just
dated,
a minute, just a minute.
my lord.
30.
Page 36, my lord.
Yes,
Yeah, it was submitted on 20, my lord.
20th
Yes,
August.
yes.
And CEO also on 20th August,
20th August, my lord.
22nd August.
Yes, my lord.
Now what do you say, sir?
All were represented in the honorable courts.
Mr.
The
Saikia,
intention
the
was on
order
that-
was stated with a particular request.
That I'm not on the contempt part, Lord.
So all right then,
The only
Now-
part is that on what order was passed on 8-9, Lordship, on that day.
Saikia,
It was
before
under-
that, the order of this court had been communicated. Your officer was not required to sit over the order for even 1 minute. We are very clear about that.
That is absolutely correct,
So,
Lordship.
all
But
right.
at the same time, the state has a right to file an appeal.
Yes.
Either we comply it or we challenge it. We
What prevented you from?
immediately order was challenged. Immediately, Lordship. The state has immediately challenged the order.
You
Because
could have,
this
you-
case is nothing to do with a particular case.
yes,
It is a wide ramification.
it has
It has
definitely.
a big ramification because
Yes,
these persons who are manning this Jilla Parishad, they always play this kind of track.
we are not bothered with who the person is. We are bothered about compliance of our
Now,
orders.
why the state has filed appeal, that is what I am submitting. And on that day, 8-9, the honorable court directed to produce the records so that all the parties were represented. The matter will be traced out on 22nd 9. Till that moment, no contempt was coming.
Very well. You argued your matters on contempt? You have completed your arguments? Anything more to say?
Lordship, there are other contemners also, if I am not wrong.
Primarily,
Yes, Lordship.
the person responsible is CEO.
The others have not filed the affidavits, Lordship.
My lord, page 38 of the contempt,
Yes.
in fact, the principal secretary had directed, if your lordship sees, my lord, this is an important document. My lord, this has been passed.
A fraud has been played with the state, Lordship, in this case. I will place that.
Sir, we are not right now commenting on the merits of the appeal.
Lord, I'm sorry.
Now you look at this
I'm
order,
leaving.
please.
I'm leaving.
Now, since you are addressing, look at the order of the principal secretary.
Page 38 of the contempt.
Not only insubordination
Let
with the
me argue
authorities.
Only on the merit, Lordship, when my turn comes.
Yes.
So this is the order, my lord, dated 26th of August.
Yes, madam. All right, tomorrow. And the general feeling is that ask your client to be here with the toothbrush and toothpaste.
May I please, your lordship? Lordship, can I get listed on the next week, my lord?
Why?
Possible, because in the meantime, I also want.
You represent whom?
The principal secretary, my
Principal secretary has conveyed to the officer that you comply with the order.
lord, my lord,
So principal secretary is
my lord,
in the correct place
my lord. Please.
tomorrow.
Number 10,
This is with impunity that he has flouted this court's order. Your officer has to be here tomorrow also.
In this case, Lordship, it is also a contempt case. There is a direction for the appearance of the Director of Elementary Education. On
This
6th,
again for the reason that despite service of notice, no one appeared.
maybe, what was the reason?
That is what the recording is in the order dated 20th April.
On that day, Lordship, the names were not reflected. For that, Lordship, maybe please say, but we have complied 50% of the.
Saikya, in a contempt reflecting of name is not relevant. The contemptor has to communicate to the counsel who is to appear.
Lordship, on that day, there may be some miscommunication, but none of the council's name were reflected in the cause list. And today the wakalatnama has been filed, everything is in order.
So the council's name would be reflected obviously on filing of wakalatnama. Before that, it could not be.
There was no fault on the part of the officer. She communicated the wakalatnama in April itself.
So that's what we are saying. Your communication systems need to be updated.
Yes, Lordship, that will do. That will do, definitely will do.
Yes.
Now regarding the compliance, there are two parts. One is to regularize
Yes.
person. The regularization order was issued on 6/5. It has already been complied.
6/5.
Yes, and we have to do some calculation regarding the arrear salary.
Okay.
That process is going on. In 1 month's time, the
You
amount will
just
also.
now see the date. Only on getting the direction of personal appearance that this order was issued.
Absolutely no, Lordship. We are contemplating because we are contemplating to go to Supreme Court.
Hmm.
Here, this gentleman was not in office for last so many years, decades. All of a sudden, he.
Yeah, not on the merits of the order,
that-
sir.
that
When
is
was the
the-
order
In
passed?
fact, if timely action has been taken, Lordship, this order would have been reversed.
What is the order dated? What is the date of the order?
There are a series of litigations, multiple litigations,
Saikya, 18.
multiple litigations. There are other litigations.
The order under contempt, please.
That-
18/2/21.
This is the second contempt. Second contempt.
Lordship, that 21, 20, this period, Lordship, may not be considered because of COVID and all. The priorities were different at that point of time.
Priorities changed in 2022. This is the second contempt.
Now we have complied, Lordship. In fact, we are contemplating to file but because of the delay part, we could not do. In fact, he is absolutely not entitled for any money.
We are
Or in-
not going to listen to a single word, Mr. Saikya.
Lordship, we are complying.
Yes.
Only we
I-
have
in a
already complied.
second contempt. Do you understand the seriousness of that? Do you want your officers to sit on top of the courts or what? You are first answerable to the court. You are an officer of the
Lordship,
court.
those person who was at the helm of affairs was, this lady was not there at that point of time. She has joined about not even 1 year now.
1 year. So the order, first order was
So for
22nd
2021,
September.
There are other orders also.
The
before that.
first order in the contempt petition was 22nd September 22, sir.
She was appeared before this court.
She appeared.
So far. The process was continuing, Lordship. The finance was creating a stumbling block.
We are not satisfied, sir, with this kind of explanation.
Then Lordship may be pleased to make one of the finance departments also, because from the education department, her role is very limited.
When did you communicate to the finance department? Let us know. File an affidavit.
Yes, Lordship, we'll file, because we filed a, yes, in August 2022, it went to finance. Much prior to the second contempt.
So all right, you file your affidavit
file
so
a
that we
affidavit.
can make observations
Yes, Lord.
regarding the finance department.
From the
Learned.
education department, the exercise was initiated 2
Yes,
years.
that bring those facts on record.
Yes, the facts I have in my hand, Lord.
Learned
We'll file in
Advocate
the
General.
affidavit.
Mr. Saikia appears on behalf of the respondents contemners. He prays or the respondent number 1 is present in the court. As directed, Shri Saikia prays for and is granted 2 weeks time to file compliance affidavit on behalf of the respondents.
Highly obliged.
They on the next date, but the personal appearance of the officer is exempted for the next date of hearing. Shri Saikia makes an oral statement that the order under contempt has been complied with,
And partially complied, Lordship,
partially complied.
partially,
Ensure full compliance in the meantime.
Lordship.
Yes.
Obliged.
Letter number 11.
May it please your lordship.
Yes.
But, this is the first time the IA has come. with a
IA.
IA for delay, my lord, of 37 days.
Mhm.
My lord, there is no private party, if your lordship consider that.
What do you say?
Lordship, in regard to his para number 3 of his application, Lordship, as such was under constant para number 3 of his application. What I found, Lordship, as such under constant medical treatment from the month of
Oh,
February.
37 days, gentlemen. Delay करना. Argue on merits. Yep.
Actually, the medical certificate that has been attested.
Obliged.
Lordship,
Don't stand on such ceremonies.
Letter number 12.
May I please your lordship, my lord, there is a delay of 349 days, my lord.
How much?
349 days. my lord.
349 days.
Yes, my lord.
Yes.
My lord, the reason is that there is a pending review petition, my lord. I have annexed the status report of the review petition, page number 8.
When was it decided?
Yeah, on 14/2, my lord. 14/2, and I have filed this appeal on 15th of March, my lord.
What do you say? Review was pending.
My lord.
The connected rate appeal is delayed by 349 days. The instant IA has been filed seeking condonation of delay occasion in filing of the appeals. The primary ground for explaining the delay is that a review petition was filed which was pending and was disposed of on 14th February 2023, which caused the delay in filing of the appeal. The reasons being sufficient, the application, the delay deserves to be condoned accordingly. The application is accepted. Delay of 349 days occasion in filing of the rate appeal is condoned. The rate appeal shall be numbered and listed for admission.
Obliged, my lord.
Highly obliged. Letter number 13.
The IA is
May I please your lordship. My lord, although the delay condonation petition is before your lordship, my lord, lordship will also consider kindly the merits of the writ appeal, only on not merits, my lord, facts of the writ appeal, because the appellant before your lordships, he is also sufferer of the delay occurred in disposal of the writ petition. My lord, what has happened in this matter? The present writ appeal has been filed, my lord, against an interim order passed by the honorable single judge. My lord, what happened? There was an advertisement issued by the Guwahati University for filling up of the post of associate professor in the Guwahati University, my lord. There was a criteria laid down by the UGC that one has to, my lord,
good academic record.
7 publications
Mm.
and, my lord, 75 marks in their credit for being eligible to appear in the interview, my lord.
Mm.
My lord, what happened? The university authorities, my lord, they have a, my lord, specific institution that is called ICQA, my lord, internal quality assurance cell, my lord, wherein the applications are forwarded. they will not calculate the marks and they accordingly issue the call letter.
Sir, you are against an interim order.
Milord, why I am saying so, Milord?
Hmm.
All these things are, Milord, placed before the honorable single judge. Milord, there is an entry, there is a, Milord, report by the IQAC saying that the writ petitioner was not eligible. Milord, the university authority also filed an affidavit before the honorable single judge saying that the petitioner was not eligible. The appellant before the single judge, Milord, filed stay vacating application praying for vacation of the interim order, Milord, but that interim order was continued. Finally, the matter was heard on 29/11/2022, Milord.
Hmm.
And till date, the judgment is forthcoming. And Milord, the petitioner is basically aggrieved by the continuation of the interim order.
Well, the judgment is reserved. How can we even think of interfering in interim order, sir?
Milord, what Lordship
That's
will
not-
kindly appreciate. Milord, the entire thing was heard and
Yes.
my results are not declared. I appeared and from the affidavit of the university as well as IQAC report, Milord, it is absolutely clear that the
You,
petitioner was
you
not
just
eligible.
give us the number of your writ petition. We'll request the learned single judge to decide the matter as early as possible. That should solve your problem.
Lordship. WPC number 4907/2022, my lord.
All right, we'll pass the necessary order. When was the order reserved?
29/11/2022, my lord.
Not too far off in the realm of uncertainty.
My lord, with all due respect, my lord, I am aggrieved primarily because honorable
So
single
thus you
judge,
can understand that once the order is reserved, final orders are reserved in the writ petition. How can we interfere in an interim order?
Lord,
That
I
will
am
be
also-
too much.
I am the petitioner appellant before your lordships also in a helpless situation because
We
the-
understand. So
in-
your solution is that we'll request the learned single judge to decide the writ petition as early as possible,
my lord,
expeditiously.
my lord,
Okay.
my lord.
Dispose of.
Highly obliged, my lord.
We'll take note of your submissions and then
My lord.
make that observation.
Yes, highly obliged.
Number 14,
May I please, Your Lord? I pray for adjournment today, my lord, because this is the, my lord, I'm against the, my lord, appeal against the judgment on order dated 12/7/2022, my lord.
Mhm,
And since then, my lord, accused petitioner are behind bar, my lord.
mhm.
So, my lord, pending the appeal, my lord, they may be released on bail, my lord, on the ground that, my lord, no independent witnesses were examined by the
What is the basic outline of the case?
case is that, my lord, when the victim was returning from paddy field, When-
Returning from paddy field.
paddy field,
Okay.
he was attacked by some person.
Mhm.
And in the FIR, there, my lord, GD entry at hospital, they stated unknown assailant. But in the, my lord, FIR, they stated that the accused petitioners are the person who has, my lord, assaulted the,
Mhm. So your case is no one saw the incident,
yes, my lord.
and thereafter, what is the evidence on which the trial court has relied upon?
My lord, evidence in the judgment, my lord, the evidence of paragraph 8, page, my lord, 15. The
Yes.
statement of PWD 1, my lord, PWD 2,
Mm.
PW2 and
So there is an oral dying declaration also,
yes, my lord,
and there are two eyewitnesses.
2 eyewitnesses.
For discarding them at this stage, you'll have strong arguments.
Yes,
All right, prepare the case better.
yes.
Counsel for the appellant, please for time. Your good name, madam?
S. Jahan, additional PP.
Additional PPS Jahan. List of 2 weeks as paid.
Not.
The names of your eyewitnesses are not there in the FIR. How you will
FIR?
substantiate?
FIR, it's there. GD entry, it's not there. But
Names of the witnesses, are they in?
witnesses are not there.
Then,
The son and the father.
hmm,
But then it has come in the evidence.
all right.
So the trial court.
letter number 15,
With your lordship,
Yes.
the matter may kindly adjourn for 2 weeks, my lord.
Why?
Because, my lord, the engaged counsel NM the Caste will not appear before your lordship because of the death of our father, my lord.
All right. It's stated that the arguing counsel has suffered bereavement and is not in a position to appear today. What is the evidence, Madam Jahan, in this case?
Here the son actually killed his
Mother,
grandmother.
oh, in the
He-
house.
Yes, in the house, he assaulted,
Evidence,
here, the injured persons, the sister,
witnesses. Oh.
sister and the mother.
You filed reply?
Yes, I filed my reply.
Okay. List up
Obliged.
4 weeks as per
Oh,
it.
pleasure.
Item number 16.
My lord, I beg to appear for the appellant in this matter, my lord.
Yes.
I could not be present physically before your lordship.
Why should-
My lord, there's an IA, my lord, which I had filed,
Mhm.
IA 963.
Yeah, that's there.
Yes, my lord.
What is the
And I
prayer
was-
in the IA?
My lord, because I have challenged the judgment of the learned single judge, which admission, my lord, no stay was granted, of course, I must say at the outset. The impugned judgment of the learned single judge has now been given effect to by way of an order which your lordship will find at page 11 of the IA, my lord.
Do you seek a stay on the impugned order now?
My lord, I am either seeking a stay or at least, my lord, an observation that, my lord, this is up or subject to the outcome in the appeal, my lord, because there is no reference to.
Need not even be said. There is an appeal. The order is under challenge. So is it required to be stated?
My lord, because they have given effect to the promotion also by drawing up a provisional seniority list, my lord, on the 12th of April, my lord. Now, in that writ petition order is mentioned, my lord, but the writ appeal is not mentioned. My colleague, Mr. Sharma, can hand over that order, my lord. Just recently it was, my lord, passed.
Mr. Nair, any objection to this observation that whatever promotions are being made will remain subject to the outcome of the appeal?
My lord,
Otherwise, need not be mentioned. But anyhow, sometimes we have to mention certain things for satisfaction of the council.
my lord, it's
So
not
that
the
they can show
satisfaction
it to
of
the parties.
council. It's not the satisfaction of the council.
Okay.
It's the satisfaction of this person who is signing. this
Appellant.
affidavit. Of the, not, it's an association, my lord.
Association.
A association which did not have a registration. Association which is not recognized by the government. It's before your lordship. No officer who is aggrieved by this order, my lord, an officer who is aggrieved by this order, he comes up before your lordship, I would not have any grievance.
All right, Mr. Council, what's your good name, please?
Mr. Abir Phukan, my lord.
So, Mr. Phukan, here Mr. Nair has got a serious objection to your application on the ground of locus.
My lord, he had filed an additional affidavit, my lord, and I had also filed a response to that additional affidavit, my lord.
Yes.
Did out, my lord, that the registration was obtained, my lord, and it has been renewed. And it's as of today, my lord, it's valid till 2025, my lord. So therefore,
Obtained
it's a-
when? After filing of the appeal?
31/12.
After filing, after filing.
After filing of the appeal. So
After filing of
the
the.
locus will have to be examined.
On the date.
It has to be examined, my lord, no doubt about that, my lord.
So what do you want us to do today?
My lord may then observe on my
Eligibility.
subject to the outcome, and your lordship may keep the matter for final hearing at a convenient date, my lord.
So there is no question of making any observation. Otherwise also the appeal is pending. We have entertained your appeal.
My lord.
We have put the other side to notice. So we'll, whatever orders are passed in appeal, of course, subject to the challenge before Honorable Supreme Court, the authorities will be bound by that.
My lord,
You want us to dispose of your IA or what?
Well, the only thing I wish to draw your lordship's attention to was this order which my colleague had handed over 12th April 2023, my lord. This-
If you are aggrieved, challenge it separately. That is the remedy.
Because they cannot be agreed because that's an association, my lord.
Yes.
My lord, here it mentions the writ petition, the last paragraph, my lord, of this order. Position of the incumbent at serial number 9.
This is a review DPC which has been held. So you are not
This
satisfied
review
with the outcome of the
review-
DPC.
My lord, I am only, my lord, aggrieved by the fact that the pendency of the writ appeal is not acknowledged in any of the orders, my lord.
It not be.
The state is represented in the writ
Subject,
appeal.
because otherwise, my lord, an equity will also arise in their favor, my lord.
would it preclude us from examining the veracity of the order simply because the appeal number is not mentioned in this order?
No, certainly it will not. Miller, then may I
Yes, hold on. Yes, Mr. Mazumdar.
On behalf of the state, I'll make only one submission. And all these we have done, including the annexure A at page 11, is in compliance with the order passed by the single judge. So we have
Yes.
to refer to the writ petition.
Obviously, because the order is not stayed. So what is the issue of referring to the writ appeal? So you want us to keep this IA pending so long as the IA is pending, your appeal will not be heard.
Miller may then list the main matter, Miller, at a short.
So what fate is to be given to the IA?
I'm not pressing it for the time being, Miller.
He's not pressing it.
For days together, we have the state.
Then Council, Mr. Pukan does not press interlocutory application, hence the same is disposed of as not pressed. The connected writ appeal, we list it for admission of 1 week, of 2 weeks.
2 weeks.
Miller, may I request for a specific date? I would like to be present, Miller.
So you are most welcome. What prevents you from coming here?
Miller, because this came at the last minute, I could not come, Miller. If it can be kept on the 26th, Miller, subject.
26th. 26th.
Deeply obliged, Miller.
Letter number 17.
Maybe the lordship.
Yes, please.
Well, this matter relates to a settlement of a fishery. And the matter has come up for admission hearing today. Parties are served. My prayer would be, my lord, your lordship will admit it and fix for this short date of hearing.
What do you say, sir?
My lord,
Though leisurely,
though the prayer looks
He's enjoying the fishery, my lord.
though the prayer looks like very innocuous. My lord, in fact, my lord, subsequently certain developments have taken place. And as a result, my lord, the ultimate as order of settlement is under challenge in a different writ petition.
all right.
And on that ground, my lord, lordship has already disposed of another writ appeal. If your lordship would like to have a look at
Let's see.
this, my lord. It will last appeal.
All right. So in consequence of this order, a fresh
Yes.
settlement has been
And
issued.
that is under challenge in, my lord, WPC 7584 of 22.
Now, my lord, the difficulty will be, there is a finding here regarding the Bakizai certificate. If that finding is
The
there. my lord,
findings may come in their way in
yes,
the
my
writ
lord, this
petition.
will
That's
come
what
there.
the
Otherwise, my lord, I had. no-
anxiety is.
No, my lord, there is one more aspect. There is one more judgment where the same finding is there, that order finality they have not sailed that way. If your lordships may kindly come to of the paper
380.
380. That's the original order, that's the genesis.
Okay.
If I may read from page 379, last 2 lines at the bottom, my lords. At page 379,
Yes,
a
please.
reading of the certificate itself goes to show that deceased father of the secretary of the society, late Mukunda Burman, had been certified that there is no Bakizai proceeding pending against him. Whereas the application made by the secretary,
Can you explain a little?
well, it's a no dues certificate.
Dues.
No dues certificate.
Just like a Ravanna or a revenue
Yes.
payment in a mutation.
Yes.
Thing that's okay.
No dues.
Okay.
Made by the secretary of the petitioner society was for a certificate in the name of the society. The very reading of the certificate makes it a case of non-application of mine. Firstly, Deputy Commissioner ought to have taken note that this is an application made by the secretary of the society for issuing a Bakizai certificate in the name of the society.
The settlement was in name of the society. So
No,
before,
No, well, actually, when a society applies, amongst others, a society is required to give a no dues certificate. Naturally, my lord, that certificate has to be in the name of the society. In this case, what had happened, my lord, the society whom we represent, the secretary applied and it was given in the father's name.
oh,
Father of the secretary. That is the only point, my lord. And it's not that any Bakizai was also there. There was no dues.
no. dues.
Otherwise also.
No, no, my lord.
Like minute. So therefore, the certificate ought to have been either in the name of the society or ought to have been refused if the facts of the circumstances so required. Further, under no circumstances, a certificate can be issued in the name of deceased father of the secretary of the society as made in the instant case. Accordingly, the certificate ticket 12.3 is declared to be untenable in law, and Deputy Commissioner is directed to give a due consideration to the application dated 2/3/2020 of the secretary of the petitioner society.
Same society, same certificate.
Same certificate. And pass a fresh order.
Yes,
And
my
this
lord.
order has attained finality, my lord.
Now, your lordship may kindly come to next page at 381, my lord.
Yes.
This is the order of the deputy commissioner pursuant to the earlier order. Now, as on that date, my lord, when the last date of filing the bid, they didn't have any certificate. This is a fresh certificate issues, not on the basis of their earlier application, because the earlier application, my lord, it was filed for the in the name of the my lord, the secretary.
His
Not
father of the secretary,
no,
who
my
had passed away.
application was in the name of the secretary. He asked for secretary. If your lordship would kindly read this 381. Message Garamadi Gaon Panchayat Nisama Samiti Limited. That
Mr.
is
Chaudhary, let us admit it.
Okay,
What difference would it make?
Okay.
The heard and counsel for the parties. The appeal is admitted. Respondents are duly served. Thus notice need not be issued. List for hearing in due course.
well, that's short date maybe fix, my lord. He is enjoying it. My
That's too much of indulgence you are asking. Then argue on merits. Argue on admission. We'll hear you right now.
There is maze of cases, my lord. That's why it will take a time.
No, don't worry about time. Don't bother, sir. We have till 4:15. We've got a lot of time at our hands.
Your lordship will give us some time in a short date. My lord. That is the only.
Then you move an application for early hearing. This is sufficient indulgence. What is the IA about?
I was for a stay, my lord. I want.
The interlocutory application is disposed of. No ground is made out to pass any order of stay in favor of the appellant.
No, I not press.
Not press. IA not press. Okay.
Letter number 18.
May it please your lordship, this matter may be kindly passed over for the day. Engage counsel for the respondent, Mr. S. Chakraborty is out of station.
My lord, a date may be fixed on Friday. My lord. There's an urgency in this matter.
What is the appeal about?
The appeal is for the.
My lord, the appeal has been filed by the management, my lord. There's an order for reinstatement with back wages. There's some urgency for us. If not on Friday, on Monday, my lord.
Just hold on, please. This order was passed in writ petition. Order was passed in a writ petition.
Yes, writ petition.
Against the order of the labor, award of the labor.
Labor, the reference made by the state government.
And counsel for the respondent has circulated an adjournment slip. Counsel for the appellant cites urgency in the matter. List on Monday.
My lord.
16.
My lord, deeply obliged.
Letter number 19 and 20.
Yeah. My lord, in this appeal, a short point is involved, my lord. Now, what had happened, my lord, if your lordship would kindly come to my lord page 45 of the appeal memo, my lord.
Yes.
Kindly see, my lord, this is the select list which was published by the Public Service Commission. This was on 22nd of January 97. Recruitment to the post of enforcement inspector under
97.
Yes. Now the issue is regarding seniority. Now 76 candidates were interviewed by the commission with the help of experts deputed by the government.
You're referring to page 45.
Page 45 of the memo of appeal, my lord.
45 is the writ petition.
My lord will have item number 20, Nikki. 20. Similar, same.
You were having the first file.
My
Sonit
lord, may
Kumar.
kindly take item number 20, my lord. Issue is same in 19, my friend appears.
I am supporting my lord, otherwise I will respond number 13, my lord.
45.
45. So, my lord, a selection was conducted by the Public Service Commission and the select list was published. Kindly see serial number 7, Manoj Kumar Chaudhary. He is the appellant. And please come over to the next page, my lord, page 46. Serial number 20, Himanshu Kumar Das, SC. Now, my lord, the learned Singular has taken a view that because I was earlier a 3F appointee, therefore he would rank senior to me.
Earlier,
My lord, initially in 1991, I was appointed under regulation 3F of the regulation. My lord.
all right.
Thereafter, my lord, there was a regular selection process took place where I participated and I was recommended.
Right.
Now, learned Singular has taken a view that this serial number 20 will rank senior to me because I was 3F, I have not been regular.
But this is pursuant to your regular selection, this list. has been issued.
Yes.
What is the rationale given to not
Yes.
to accept this list?
Yes. My lord,
Let's
will
see.
kindly come to the impugned judgment, my lord.
Yes, please.
Impugned judgment, lordship will kindly come to page 204,
Para.
para 22, my lord.
These are, they were selected on what post?
Enforcement inspector, my lord, in transport department.
Transport Department. 24 you are referring to, para
204, my lord, para 22. I'll read some
22.
paragraphs.
Yes, please.
It is seen that while communication bearing dated 22/1/97, chairman of the APSC had informed the secretary to the government of Assam Transport Department that 76 candidates were interviewed by the commission with the help of experts.
What was the mode of selection? Only interview.
No, my lord, it was initially written state asli, na? Written test followed by interview.
This observation in para 22 is.
Yes, yes, it is regarding interview, yes.
Oh, okay.
No, if the selection is bad, it will be bad for everybody. Interviewed by the commission with the help of the experts deputed by the government and recommend names of 47 persons in order of preference for recruitment to the post of enforcement inspector under Transport and Tourism Department. This said communication does not indicate whether apart from interview, any recruitment process was held for selection. As per the provisional gradation list dated 24/8/11, name of the petitioner Gautam, he's another person, my lord. Now we are not concerned with this. So and so. Lordship may kindly come over to the next page.
Petitioner is of course this Manoj Kumar Chaudhary.
Manoj Kumar Chaudhary.
Yes.
My lord, at para 24, the learned single judge discusses more about my lord Gautam Kumar Das. So I'll not trouble your lordships with that. Lordship may kindly come over to page number 206.
Yes. Paragraph.
No, my lord, it's a whole para. I'll line about the sentence starting with however, somewhere in the middle, my lord. However, the fact remains, has your lordship got it, my lord? At page 206, line about 1, 2, 3, 4, 5, 6, 7, 8, line about.
However,
9.
the fact remains
Yes,
appointment of
yes,
Manoj Chaudhary.
Yes.
Yes.
However, the fact remains that appointment of Manoj Kumar Chaudhary was made under regulation 3F of 51 regulation, which was not extended from time to time. And said respondent did not render any service from 8/9/97 to 9/2/21. As per the gradation list dated as on 11/5/18, it is not in dispute that APSC recommendation, the name of Manoj Chaudhary appears at serial number 7. Therefore, order of the government under notification dated 26/06 is found to have preceded the APSC recommendation. Therefore, insofar as petitioner Gautam Kumar Das and Himanshu Kumar Das are concerned, said Sri Manoj Chaudhary has to be placed below. It may be mentioned that Himanshu Das in the direct recruitment is a direct recruit and his position in the APSC recommended list at serial 20 of 22/1/97 because the said gradation list as on 11/5/18, the name of Manoj Kumar Chaudhary is reflected as an appointee under regulation 3F of regulation. Therefore, a direct recruit would have to be.
From does this observation come?
I don't know, my lord. With all respect, my lord, I don't know, my lord, there is no dispute that there was a selection process. And my lord, kindly have a look at the rules, my lord, how seniority is to be determined.
Yes. Any previous discussion on what basis this observation comes in? That appointment was made under rule 3F.
In fact, my lord, before that, can I place the petitioner's perspective in the matter, my lord? Just one paragraph. My lord, may kindly have a look at page number. Civil rule code bolay. Please come to page 59, my lord.
Yes.
Sorry. Repetition. Yes, I'm sorry, my lord. Please come to page 95. Or precisely at page 97.
Yes.
That the petitioner humbly begs to state that the impugned final gradation list, the petitioner has been wrongly superseded by individuals being respondent number 5 to 14. That for the sake of convenience, different categories of respondent who have superseded the petitioners are mentioned below. Now, this is how he explains, my lord. Then please come to page 98. It is contended by the petitioner that it is no longer a sitigra that an ad hoc employee or for that matter an employee appointed under Regulation 3F of the Assam Public Service Commission Regulation 51 shall not be entitled for seniority from the date of his regularization. Although the recommendation dated 22/1/97 contains the name of persons appointed under Regulation 3F of the Assam Public Service Commission Regulation.
So is there just hold on. Is there any subsequent order of regularization of this
No, my lord.
appellant?
Nothing. No, my lord. Well, it's a very simple, my lord. Because I was appointed under Regulation 3F to become a member of the service, I must be appointed in accordance with the rules. And in accordance with the rules is a selection by the Public Service Commission. And I have been appointed and I've been selected at serial number 7. Well, I am yet to come across a jurisprudence where the proposition which the learned single judge has held has ever, I'm sorry, my lord, there could be. If my learned friend enlightens me, it's very well and good. But to me, my lord, it doesn't appear.
We'll give them that opportunity.
Yes.
Yes. Okay. Yes. Where does this finding come from? That the list of 97 is as a result of appointment under Rule 3F.
Two of the most relevant aspects have not been placed before your lordship. Let me place
That's why you have got the opportunity.
My
First explain this order.
lord,
Where does it indicate that this is an appointment under 3F?
the order that was impugned has not been placed before your lordship. Assigning, determining seniority, that your lordship will find at page 85.
Yes.
This itself will make the position very clear. And in fact, some other relevant facts. Page 85. This is what was under challenge. The governor of Assam is pleased to finalize the provisional gradation list of enforcement inspectors, etc. Now, if your lordship, the relevant gradation list, your lordship will find at page 87.
86.
87. 86 is a typed copy extract.
So read that.
The one in original, your lordship will kindly come to the 5th column, mode of recruitment. In respect of serial number 16, that is the appellant before your lordship. Your lordship will see mode of recruitment is 3F. So 3F is an ad hoc appointment which he.
Oh, sir, you come to the type copy first. That recruitment was in 1993. In 1997, this is a regular recommendation.
That is precisely the case, madam. What had happened was,
yes,
there were 2 sets of selections made. They faced a mere interview. We faced a written followed by an interview. And this is a pleaded position, not disputed.
Where do you get that from? Where do you get
but this is pleaded.
Whether the APSC is represented?
My lord will kindly come to page 178.
Yes.
My lord will kindly come to page 178. This is my pleaded case at para 7. This is an affidavit that was filed by me before the learned single judge. Para 7. That with regard to the statements made in paragraph 10 of the affidavit in opposition, the answering respondent, deponent begs to dispute and deny the same as the said statements are not tenable in law. The answering deponent.
Ms. Chaudhary.
Well,
Assuming that he was taken simply through an interview, just hold on.
Well,
The list was published in 1997.
Precisely.
The list indicates regular selection by APSC, right? Did you challenge it any place?
My lord will have a look at the consequent subsequent fact. On the moment the list was published, he was involved in a criminal case. He was placed under suspension. His services were terminated. Till 2001, he remained terminated. Ultimately, he is given an appointment, substantive appointment in 2006. The basis for that, now as it is claimed, is he had challenged his termination in a writ petition. There, the Honorable Single Judge was pleased not to stay the termination, but an observation was made that the select list will be kept alive. Now, in 2006, he gets a substantive appointment and he is being given seniority, assigned seniority from 1997, when he was not even in service. His services, all these facts have not been placed. The page 205, 204 and 206 of the judgment were placed. But the most relevant portion, your lordship will kindly come to page 205.
So
These facts,
just hold on. The termination was challenged in a writ petition, right?
Mal.
So whether the termination order was quashed with a retrospective effect?
No.
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 Okay.
Your lordship will kindly come to
Yes.
page 205. This portion was not placed before your lordship.
All right. They will place whatever suits them.
My lord,
You are here
my lord.
to
That is
watch
why
your
I'm
client's
placing it, my lord.
interest.
If your lordship will kindly come to para 24. These facts are the most relevant facts for determination of his seniority at least.
Just let's see.
Para 24. The case of Gautam Kumar Das petitioner in WPC number so and so is examined first in the context of Manoj Kumar Chaudhary.
Mm.
As per the gradation list as on 11/8/2018, the said respondent was appointed as enforcement inspector on 12/2/93. However, he was suspended by notification dated 31/3/97, and thereafter his service was terminated by notification dated 8/9/97.
Mm.
It is seen that the said respondent number 9 got reinstated in service in light of orders passed in civil rule number so and so, and that during the pendency of the writ petition, the order of termination was revoked by government notification dated 9/2/2001.
Mm.
And by another notification dated 22/3/2001, the order of suspension was revoked.
Right.
And the petitioner was reinstated and his
So revocation would have an effect as if it was never in existence.
no revocation, what it means, he was brought back up regulation.
It can't be fresh service, sir.
No.
Revocation of an order of termination would mean that the order has been wiped off.
No, man. If your lordship will kindly see his order of appointment, that is what is relevant.
Yes.
That he was never substantively appointed till 2006. That your lordship will find.
Where is the order of revocation, please?
Order of revocation, I don't think they have annexed. If my lord will, that is not, that has not been placed on record. 68. Asami.
Read page 156, please. Somehow or the other, the correct page which is required to be seen lands up before the court.
My lord, the governor of Assam is
This is Manoj Chaudhary.
Manoj Chaudhary.
We are dealing with the case of Gautam.
No, Manoj is the appellant.
Read
The
156.
governor of Assam is pleased to drop the departmental proceeding drawn up against Manoj Chaudhary, so and so, exonerating him from the charges. The period of suspension is also is treated as on duty for all purposes. Now, if your lordship will kindly come to the next page,
Yes.
page 157. In pursuance of that select list of 97, this is a substantive appointment.
Yes, appointed with effect from
Exactly.
22nd January 1997.
What the honorable single judge has held
Yes.
is, could he have been given the benefit of seniority for the period when he was not
Read
even.
156, last two lines, please.
Mal. His period of suspension also is treated as on duty.
Duty for all purposes.
But
So where is the termination order, sir? There was a charge sheet served. There is no termination order.
there was a termination.
Where is it? Point out. This order doesn't convey.
No, but there was a termination order.
There was a D going on against him that
Yeah.
was dropped.
My lord will kindly have, this is not placed on record, but it is stated in their own appeal. Para 3 of the writ appeal.
Mm.
These documents, I obviously don't have access unless he places it.
Yeah. Why would he has placed the relevant document which indicates
My lord
it
will,
was a suspension.
my lord
and-
will kindly have para 3 of the memo. Appeal.
Read please, para 3.
That the appellant was alleged to be involved in a criminal case and he was,
Placed under suspension.
the appellant was placed under suspension and subsequently filed another notification dated 8/9/97.
So the termination order was stayed ultimately.
Not stayed.
Yes.
Termination order was never stayed, my lord. If you kindly have the order by the honorable single judge, that your lordship will find at page 57. My lord.
Mm.
The interim order that was passed is extracted. This is the final order. The interim order is extracted in that at page 58. My lord.
It seems to be an error in their pleading. So D, it was a suspension. There is no termination as such.
There was a termination. My lord, that is what was under challenge. Your lordship will kindly have a look at the honorable single judge's.
Where is it? Where is it?
Page 57. My lord.
57.
57.
That is the earlier writ petition.
Heard the other repetition where the termination itself was challenged.
Yes, that's it.
Second paragraph, the petitioner Manoj Kumar Chaudhary was appointed as enforcement inspector for a period of 4 months by order dated 4/2/93, as provided under regulation 3F of the so-and-so regulation 1951. While the said period was extended from time to time and while the petitioner was so serving, he participated in the selection process pursuant to the advertisement issued by the Assam Public Service Commission. Although the advertisement was for 20 posts, but it was restricted to 14 posts only, and the Assam Public Service Commission issued a select list on 22/197, wherein the name of the petitioner appeared at serial number 7 on the merit list. The petitioner belongs to the general category. However, the petitioner was involved in a criminal case for which he was detained, and by notification dated 31/3/97, he was placed under suspension. Thereafter, by notification dated 8/9/97, the petitioner's services were terminated, and the petitioner has filed the present writ petition challenging the said order of termination for a direction to regularize the service of the petitioner, as per the select list published by the Assam Public Service Commission.
Yes,
This was
yes.
the prayer made in the writ petition. Now, the interim order is extracted in the middle of the page. By the interim order dated 21/1/98, this court provided as follows. In the meantime, the validity of the select list dated so-and-so shall stand extended, and one post of enforcement inspector in the Department of Transport, Government of Assam shall not be filled up.
Is that revocation order on record, please?
My lord,
That revocation order, where is it?
at page
9th February 2001. Where is that order?
1 second. 9 February, 9 February, 9 February, think you're still? My lord, as far as we are concerned, my lord, one second.
That has not been placed on it.
Mr. Chaudhary, the
Yes.
issue is that if he was under termination
Yes.
for 4 years, how could those services be counted? As a matter of fact, the select list was never given effect to for the petitioner.
No, my lord.
Was there an-
No, kindly see the final order passed in the writ petition.
Let's see.
Yes, which my learned friend was reading, my lord.
Yes.
Yes. Page 57.
So one post was
Yeah, vacant.
filled up.
No, yeah, no, kindly see, my lord. Yes, not to be filled up. On the page 59, my lord, last para, in view of what has been stated above, this writ petition stands closed with the observation that on disposal of the criminal case as stated above, the respondent shall take a decision in the matter, and till then the interim order passed by this court shall remain valid. Now precisely thereafter, my lord, at page 67,
Yes.
this order was passed.
Yes.
The one which you read, the lordship read at 156.
Hmm.
Governor of Assam is pleased to drop the departmental proceeding drawn up against Sri Manoj Kumar Chaudhary, enforcement inspector, by dated so-and-so, exonerating him from the charges. His period of suspension.
But this
also is-
dropping is in 2006.
Yes,
But the termination proceedings were earlier.
yes. No, in fact, this is 9th of February 2001. It was white so-and-so.
Where are those?
Actually, my lord, because of pendency of criminal case,
Hmm.
a disciplinary proceeding was also drawn up against the petition.
But whether there was a termination as such,
My lord, I think, my lord, there is some loosely used expression, my lord. The
that's what,
termination, it could not have been, my lord. Even I.
broadly speaking, it could
Yes,
not have been.
could not
Without
have
an
been.
inquiry, it could not be.
DP was initiated. Now, when, my lord, it says that my period of suspension would be.
We'll have a look into his service record. All these
Yes.
things will be available.
Yes,
All right, who will bring the service record, please? You are having it.
but my lord, on the other point, the learned single judge, my lord, that point has to be clear. Otherwise, my lord, selection will make no sense.
You get his service record, complete service record.
Of the appellant manner.
Yes, day after tomorrow. Then comment council. What's your good name, madam?
MD Bora, Standing Council, Transport Department.
Standing council, APSC,
Transport, my lord.
Transport Department shall keep the complete service record of the appellant available for the court's perusal on the next date. List on 12th. 12th.
12.
Well, so far 19 is concerned, well, that may be admitted because it is same, well, judgment we have.
19, we'll consider it on same day.
But it's same, well, we are same thing, well.
Wait for it.
Right.
Termination must not have been,
Item number 21.
could not have been. Because this is, you see, the revocation order says time under suspension. That is regulation. If it is revoked. No. Maybe less of convention. Maybe for period between suspension and will not get the full pay. But anyone was the proceedings are dropped, the entire period gets regularized. We'll see that, because once even if it is assuming termination, if that is revoked or quashed, it has the effect of retrospective. It goes back into time. Unless there is a specific order that now the services will be counted from henceforth, which can't be claimed. Yes.
But in this case, my lord, the education department was supposed to file the affidavit, but they have not responded yet.
In fact, I have received some instruction. I'm
Mm.
praying for some accommodation for today, madam.
Mr. Mazumdar, Standing Council Education Department. That was the very order passed on
Last occasion.
Yes,
11th April,
yes, madam.
when Council representing the Education Department praised for and is granted further opportunity of 2 weeks to file the affidavit
I
Obliged
will
to-
pray
in
for a
terms-
date. I will-
in terms of the earlier direction list on 30th May.
oblige,
I'm
Lordship.
obliged.
So number 22,
Criminal.
My pleasure, Lordship.
Yes.
Lordship, there's a writ application has been filed, Lordship, against the order of the detention.
Preventive detention,
Lordship,
PIT and DPS.
Lordship. Dated 6/12/2022, Lordship. So for the case is concerned, Lordship, the detainee was arrested.
Has the order been confirmed?
Lordship, order has been confirmed, Lordship.
Where is the confirmation order? How many cases
Yes.
against this man?
Lordship, it has been shown that 6 cases has been getting, Lordship.
And what is your ground of challenge to the order?
Lordship, the inordinate delay in disposing the representation, Lordship.
How many
There is a
days? How many
70
days?
It is around 78 days, Lordship.
78 days.
Lordship,
All right.
the first ground. And secondly, Lordship, at the time of the furnishing the order, the documents
Were not
upon
provided.
which were not.
Relied upon documents were not provided.
Not provided, Lordship. That has been specifically mentioned in the representation, Lordship.
Where is the order of confirmation?
Order of confirmation, Lordship, will find page 36, Lordship, 6/12/2022. Type copy is there, Lordship.
This is not the order of confirmation, gentlemen. The order of confirmation is passed pursuant to receiving the report of the advisory board. Where is that order?
Lordship, that order has not been passed, Lordship.
It
That
can't
has not
be.
been- that has
If
not
that
been-
order is not passed, the man can't be kept in custody. Issue notice to the respondents. I don't think you were not there. You were not there. Probably Justice Sumitra was there. There was no order of confirmation. As you took an affidavit from- No confirmation order was passed. Can't be kept in bars. You find out from the prison, the order of confirmation must have been served. Can't be.
But it's so, but the communication received, Lordship, this is the last order that was communicated to the
The
detainee.
maximum period of detention without confirmation can be 3 months.
Lordship,
That is what that says.
Lordship,
So where is the confirmation order? This is rejection of your representation.
representation, Lordship.
Confirmation order we need. We found one case wherein there was no confirmation. Mr. Mazumdar probably appeared in that case. Yes. Issue notice, the order is by the state authorities.
Yes, my lord.
Lordship,
Mr. Nath appears.
For two
For
to six.
response numbers,
2 to 6, my lord.
response number 2 to 6, central government. Response number 1. Sufficient copies of the writ petition and the annexures be provided to Lieutenant Counsel representing the respondents who pray for and are granted 2 weeks time to file reply oblique affidavit.
obliged, Lordship.
To find out if there is no order of confirmation, every minute's detention is illegal.
Next week.
Seems your officers don't know the procedure,
It seems, my lord. It seems.
apparent. So why don't you come out with a statement post lunch, whether there is an order of confirmation or not? Find out from your secretary, they'll be having the order.
Or
Come back with this statement.
or kindly keep it up to tomorrow, my lord. In the meantime, I'll get back, my lord.
Once just post it tomorrow,
Tomorrow, my lord. Lordship.
Lordship.
because if there is no confirmation, the order goes,
True, my
the
lord.
detention is illegal.
Yes, true.
tomorrow. Just simply list it tomorrow.
Obliged.
Number 23.
Actually, Mr. Nath, these detention orders under PIT used to be done by the central government authorities. The NCB and the CBN, they were the nodal agencies. They were experts. State authorities have no idea about these laws, basically.
Power has been given under 3-1, but
They are not trained, basically. That's the problem. Even in that case, we found the advisory board's report was beyond 11 weeks.
Yes.
It's totally vitiates tomorrow.
May I please, Your Lord?
Yes.
Lordship,
Take down in this, Mr. Not appearing for the state authorities shall apprise the court regarding the order of confirmation, if any, passed, authorizing the detention of the petitioner beyond 3 months.
Lordship.
Yes.
Lordship, in this case, Lordship, the government of India has taken the initiative to develop the Indian road transport infrastructure under the Bharatmala Provisional Project, Lordship. And accordingly, Lordship, in the district of Kachar, Lordship, one east-west corridor, Lordship, which was started from the Silchar town, Lordship, up to Bairinti, Lordship. And under this project, Lordship, one notification was issued on 5/1/23, Lordship, Annexure 1, Lordship,
Yes.
page 19. Under this notification, Lordship, merit, Lordship. In exercise of power conferred under subsection 1 of section 3A of the National Highway Act 1956, thereafter referred as the said act, the central government, after being satisfied that for the public purpose, the land, the brief description which is given in the schedule below is required for building, widening in 2 lines with paved shoulders, 4 line, etc. Maintenance, management and operation of NH 306 in the stretch of land 0 to 20 kilometers in the district of Kachar, Lordship. Whatever, Lordship, this notification was published in respect of the land scheduled under 306, Lordship, NH 306, Lordship. But in practically, Lordship, land was they are acquiring under NH 37, Lordship. That is the main grievance, Lordship, of the petitioners. And accordingly, they have approached the Deputy Commissioner of Kachar, Lordship. Page 21, Lordship.
Yes.
Their representation, Lordship. Ventilating their grievance,
We
Lordship.
will ask the Deputy Commissioner to examine your representation objectively. What else? Otherwise, these are disputed questions of facts.
Lordship.
You are not given the representation to the NHAI. What is the point? Where is it?
Page 34, Lordship. Page 34, Lordship. Through email, it was communicated, Lordship. The email consentment also annexed, Lordship, is page 33, Lordship.
We will direct them to decide consider your representations objectively. Dispose of, to pass a reasoned order within 4 weeks. Disposed of.
Highly obliged.
Okay.
Number 24.
May it please your lordship. May I have your lordship's permission to address?
Sure, please.
My lord.
You
My
don't
lords,
need
this-
our permission. Our court is open, sir.
My lords, my lords.
Yes.
Deeply obliged, my lord. This writ appeal is directed, my lords, against the judgment and order dated 17th March 2023, passed by the learned single judge,
Yes.
upholding the cancellation of the select list in which I was placed at item number, serial number 1, and directing for re-advertisement, my lords. May I place the facts, my lord? There was a advertisement for recruitment of 1 LDA in a high school. The selection process comprised of written test, typing and computer test and interview. Now, on 1st of February 2016, which your lordship will get at page 65 and 67, your lordship will find that the petitioner was placed as serial number 1, that your lordship will find at 65. And at 67, he was, by the selection committee, recommended and placed at serial number 1 in the select list. That your lordship will find at 65. 65 is the final result, and that your lordship will see there were 19 candidates who participated in the process. And at 67 is the recommendation. We originally, my lords, in the earlier round of litigation, because appointment was not taking place, approached your lordship. Your lordship, in writ petition number 4620, was pleased to dispose of the writ petition by order dated 2012-2016, which your lordship will get at 79 to 83, at 83, directing the authorities to either take the select list to its logical course within 30th December 16, or take a call whether if they cancel the selection process to assign reasons. Now, after that, the impugned order came to be passed on 30/12/2016, which your lordship will find at page 85. Now, before I take your lordship to the impugned order, the impugned order is premised on a complaint by 8 unsuccessful candidates that your lordship will find at page 120. The select list was published on 1st of February 2016. And if your lordship sees at 120, the complaint is dated 5th of February. And out of the 8 candidates who represented, 4 did not appear in the written test, 2 were absent in the typing and computer test, and 2, in fact, participated in the process, took their charge. After they don't find themselves in the select list, they make a complaint. So the basis of the impugned order is founded on this complaint dated 5/2/2016, filed by 8 candidates who took their charge after having participated in the process. So it is after the process was completed, they then make a representative. After having participated in the process, having failed. Now, if your lordship now comes to the impugned order, my lords, at page 85.
Yes.
My lords, may I read, my lords?
Yes.
My lord. Seeing the Honorable Court's order dated, my lord.
Before that, sir, will you please let us know whether
My
the headmaster is the recruiting authority under the rules?
No, recruiting authority is not the headmaster. He is.
When the advertisement, who issued the advertisement? Who issued the advertisement?
Page 62, my lord, the
Read, sir,
advertisement.
we are on that 64.
My lord. This was issued by the headmaster, my lords.
That's now the question again. Please rethink on the question we have put to you.
My
Whether the
lord.
headmaster is the recruiting authority under the rules.
My lord, the rule 2003, I'll just get back to your lordship. The 2003 provincialization rules deals with
Yes,
it.
let us see.
My lords, if your lordship has the 2003 rules.
Education manual.
Yes. Now it has been amended. Now the 2020 is the, but
2003 rules you are having, Mr. Counsel.
Page 368 would be relevant.
368.
368 would be relevant.
363.
368 starts, my lord. For LDA, the advertisement process is at 368.
All right, let's see. Is the headmaster a competent authority?
Yes, my lord. He
is.
Yes. Rule 4.
Rule 4.
Rule 4(2).
The principal, may I read, my lord?
He is the appointing authority.
The appointing authority is the inspector of schools, my lord. The recruitment is done school-wise, so the vacancy is advertised school-wise. Ultimately, the inspector of the school is the appointing authority. He looks into the entire appointment.
But the advertisement can only be issued after approval of the inspector of school.
My lord, yes.
Is it your case that the approval was there?
Yes. For the
It was there.
advertisement, there was no difficulty, my lord.
All right. Okay. Yes, carry on.
My lords, that is, my lord, the issue is, my lord, your lordship has already been apprised on that. Page 85 is the reason of the cancellation and the decision to re-advertise, my lords.
Yes.
Seeing the Honorable Court's order dated 2012-2016, passed in writ petition 4620 of 16, filed by Jiten Saikia, that is the petitioner, my lord. This is the earlier round which I was alluding to. peruse the complaint petition submitted by Rajiv Bora and 7 others. This complaint is dated 5/2/2016. Your Lordship will find it at page 120 of the writ appeal. Who appeared in the interview for the post of junior assistant, Pubnoloy Madhav Kandoli High School. It has been alleged that the headmaster Pubnoloy Madhav Kandoli High School had not kept the answer script in police custody, but in his own custody, for which favorable candidates was able to secure position. In this petition, it is also alleged that a news item was also aired on 23/1/16, that is prior to the written test on 30th, in the electronic media Prague News at so-and-so AM at night, recording taking bribe by the headmaster from a candidate, not me, my lords. Peruse the statement of the headmaster. This is the explanation given by the headmaster. Pubnoloy High School, given on 26/2/2016, the headmaster of the school stated that no candidate was allowed in the typing test without diploma in computer knowledge and typewriting. My lords, the advertisement, there's a gray area which I'll address, your lordship, because the advertisement says one must be a diploma in typing with computer knowledge in computer application. But they have disallowed, but no aggrieved parties before your lordship. It has also been stated by the headmaster that the school, that the answer scripts were kept in the school instead of the police station, as there is no almirah in the police station. He also stated that although one candidate had forcefully gave bribe of an amount of rupees 1,20,000, and the news published, Prague News Channel is not based on fact. Now, peruse the statement given by the principal in charge high school, supervising officer in the written examination and typing test for the post of so-and-so school, that after completion of the written examination, the answer script were kept under seal cover. This is important, and she went to the police station along with the headmaster of the school to keep the answer script in police custody. In the police station, she asked the headmaster to keep the answer script by observing necessary formation. Thereafter, on the next day, she had reached the school and opened the sealed packet of the answer scripts in front of 4 number of examiners. She also informed that there was no anomaly in the written examination. The activities of the headmaster cum member secretary created doubt in the minds of the candidates about the transparency of the selection process. The headmaster did not keep the answer script in the police station merely on the ground that there is no almirah in the police station, and he did not inform the matter to the authority or the selection committee. Under the above facts and circumstances, I am of the considered opinion that the post of junior assistant in so-and-so should be filled up through re-advertisement. Your lordship would see, my lord, that the principal says the version of the headmaster is that when they went to the police station, there was no almirah in the police station. So unlike the complaint, which says that he kept it in the residence, the answer script was sealed and kept in the school premises. And when it was opened the next day by the principal in the presence of other examinators, they found no anomaly. My lords, that now, my lords, this is the basis, this order was impugned before the learned single judge. The affidavit placed the version of now the single judge, if your lordship sees page 124, is a short order from 124. Basic point which I seek to raise is, my lord. Your lordship, before that, your lordship, I've already taken your lordship to the fact that these unsuccessful candidates chose to participate, and after having failed, they now are making a complaint. The specific your lordship will get at page 109.
Yes.
Affidavit. That I'm just alluding to. Your lordship may just note page 109 of the writ petition at
Yes.
para 21. I won't take your lordship to that. 125, my lords, the learned single judge starts, my lord. May I read from para 4?
Yes.
Where my lords are contention, because in spite of court direction, the records pertaining to the cancellation process was not placed before the learned single judge. And if your lordship sees the para 4, at the outset, it may be mentioned that the learned senior counsel for the petitioners has raised doubt on the correctness of the reasoning given in the impugned order because the failure of the secondary education department to produce the records even after 5 long years and despite several orders passed by this court for production of record. In this regard, the learned standing counsel for the petitioner has submitted when the matter was last listed on 10/3/23 had received the WhatsApp message from the competent authority informing him to the effect that the relevant records were sent to the headmaster of the school to the office by the headmaster of the school to the office of the inspector of schools, Nagaon District Circle. And accordingly, the records were forwarded to the then standing counsel for secondary education department by forwarding letter dated 2/5/18. However, it has been submitted that despite his efforts, hands could not be laid on the said record. Therefore, with the consent of both the sides, matter was heard in the absence of the record. My lords would now come to the reasoning in 2 paragraphs. If your lordship just have a look at page 129, para 9. This is the reasoning. It starts from 8, but I'm taking the lordship to para 9.
Yes.
Thus, it is not the case of the respondent number 4 and 5 that the officer in charge of the concerned police station has refused to keep the answer script. It is also not the case that the prior permission was taken from the inspector of schools or the selection committee or the governing body to store the answer script at his home. Well, this, my lord, with respect, even the impugned order notices that it was not kept in his home. If your lordship sees, the learned single judge proceeds as if the answer scripts were kept in his home. It was kept in the school premises in sealed packet, my lords. Therefore, from the impugned order dated so-and-so, it appears that the respondent number 4 and 6 took a decision, that is the principal and the headmaster, took a decision not to store the answer script at police station due to the lack of almirah. Moreover, the candidate did offer bribe to the respondent 4, and the news of the offer of bribe became viral in a news channel, TV news channel. In the advertisement, it has been stated that application invited for the post of one LDA at so-and-so school, qualification, HS pass, diploma in typewriting, Assamese English with computer knowledge. However, as per the impugned order, the respondent 4 did not allow candidates to appear in typing test without diploma in computer knowledge and typewriting, which is not as per the scope of the advertisement, which requires diploma in typewriting, English and Assamese with computer knowledge. Under such circumstances, notwithstanding that some of the candidates did not appear in computer skill test, this is on the plea of estoppel, my lords. The court is unable to find fault with the decision of the inspector of school so-and-so to direct the post of so-and-so to be filled up by re-advertisement. Then at para 12, I am given the benefit that if I'm overaged, then that may be considered, my lords. Based on this, my lords, I quite see, my lords, one's inclusion in the select list doesn't close him with any vested right, but it is equally well settled that the cancellation of a select list also must not be arbitrary. So the question, my lords, the question that I pose, my lords, this is based on a complaint made by 8 unsuccessful candidates, 4 of whom who did not appear, 2 who were absent. That's why if your lordship sees at page 65, may I take your lordship to page 65? Who were the candidates? My lord, if your lordship has page 65.
Yes.
My lord, 4 people did not appear in the written test at all, but 4 participated in the process. If your lordship sees at page 65, serial number 2 and serial number 16, Miss Pallavi Bora and Manoj Bora, they were absent in the computer typing and oral. So far as serial number 5, Rajiv Bora, and serial number 18 is concerned, Rajmani Saikia, your lordship would see that they participated in the whole process. They were unsuccessful. The Prague News channel came on 23rd. The written test was held on 21st. Then comes the Prague News channel report on 23rd. Then the typewriting test and interview takes place on 30th. Then on 2nd, the select list is published. You wait till 5th of February after realizing that you were unsuccessful, you make a complaint. That is my first submission, my lords. This is the whole basis is based on a belated complaint by unsuccessful candidates.
Very well,
Therefore,
sir.
my lord.
Okay. Anything else to say?
My lords, on the second, if your lordship sees at para 9, the learned single judge has proceeded on the basis as if the answer script was kept in the house of the residence.
Yeah,
of the,
you already referred to that.
I quite see, my lords.
Yes. No need to repeat.
My lords, my lords.
Anything else to say, sir? Yes.
The orders of the judgment of the learned single judge at page 128, para 8 has been given a go by while arguing. Para 8, my lord.
Yes.
Page 128.
Yes, read.
It is seen in the affidavit opposition filed by the respondent number 4 and 5. The respondent number 4 has denied the allegations as false. Nonetheless, in para 6 thereof, it is admitted that the father of a candidate tried to bribe the respondent number 4 and he refuses, scolded him. Thereafter, my lord, in the next page at page 129, no candidate was allowed in the typing test without diploma in computer. Well, the
That's
process
right.
in the advertisement was
Process was vitiated.
It was
Yes,
vitiated.
apparently.
The other part, and the inspector of school is not told that we are not allowed to keep it in the police station. Let me take it to the school. Even that is not informed.
All right, all
Even
right.
all this, it's a re-advertisement.
Dismissed.
Obliged.
Deeply obliged, my lord.
Call out.
Item number 3 passed over, madam.
This one is 24.
Actually, my lord, yesterday, my lord, they take permission and consent for the adjournment, my lord.
It's all right. What we wanted to know,
Yes.
whether the selection process has been completed.
Completed already by appointment, they were made.
All right, you come out with that statement
My
on
lord.
Monday,
My lord,
list on Monday, 15th.
must. In fact, that is the one of the ground that non-joiner of necessary party. On that ground, it was ejected.
Item number 26 of daily list.
Made later also. Miller, during pendency of this appeal, Miller, the appellant number 2 died last week, Miller. May I pray for some time to being on record, the representative of the appellant number 2.
And then appellant number who has passed away?
The appellant number 2, Miller, Dipankar Deka.
During pendency of the appeal, the appellant number 2 has passed away. Then counsel for the appellant, praise for and is granted. 4 weeks time to bring his LRs on record.
My lord.
Item number 27.
Lordship, item number 27 to 31, Lordship, may be taken some other day. I'm appearing on behalf of appellant counsel. There's some personal difficulty.
Why they should be taken on another day? Just on the asking of the counsel. Is there a presumption that the counsel says that it should be adjourned and the court should adjourn it at the drop of the hat? Why are they to be adjourned? Show us some reason.
There's some personal difficulty to Lord.
In every case, there is a personal difficulty, so the matter should be adjourned. It's not really fair at all.
Then Lordship, after some time, I mean, inform him.
All right, pass it over. You are appearing for?
Responding lordship.
Where is Mr. KL?
He on legs here.
On legs. That can't be a ground not to appear in division bench number 1. That is discourtesy.
I'm sorry.
We are passing it over. Call him.
Obliged.
Letter number 33.
What is this mail about?
May I please your lordship, I am appearing on behalf of Geetaka. They were supposed to file an affidavit.
Lordship, as per my instruction, affidavit is sent for vetting, Lordship. So some more time may be granted. It is not written.
MS so you are appearing on behalf of Mr. Chaudhary?
Yes, Lord.
Associate to Mr. RKD Chaudhary, PSJ submits that the affidavit has been sent for vetting and would be filed shortly after list after 3 weeks.
Obliged.
Letter number 35.
There's no one. 5.
I'm extremely sorry, ma'am. I'm for the respondent in this case.
Mhm.
On behalf of the appellant side, no one is appearing.
None for the appellant list. Is there someone? List up to 4 weeks.
Deeply obliged, madam.
None present, matter was called up, none present for the appellant, list of 4 weeks. Yes.
May it please, your lordship. Your lordship, the challenge here is to be ordered dated 24/3/2022, your lordship, which is at page 162. The issue that we have assailed, your lordship, in the writ appeal. The matter here pertains to a no confidence motion, your lordship, which was taken against the appellant by the ward members, your lordship. The issues that you have relied on in the writ appeal, your lordship, is the fact that the time scale which is granted by section 15.
Okay. Yes.
Yes.
Hmm.
The issue here, your lordship, we have assailed, your lordship, the order dated 24/3/2022.
No confidence motion was challenged.
Motion, your lordship, against the appellant on the
Yes.
sole ground that the time prescribed under section 15, read with section 17 clause 3, has not been followed in the instant case, your lordship. Before I proceed with my submissions, if your lordship can kindly provide into division bench.
Yes.
Your lordship. On page 6 of the judgment, your lordship. This has been held by the division bench of this court. It is therefore absolutely clear that 3 days clear notice has to be given for a special meeting. This was not given as by the communication dated so-and-so, issued by the deputy commissioner. The meeting was called on so-and-so, that is the next day. It is hence a clear violation of section 17(3) of the act. These anomalies, though noticed by the learned single judge, yet the learned single judge was the view that no proceedings have been caused. By this, the appellant.
How does the learned single judge deal with this argument?
Yes, your lordship can.
In this case?
Yes. If your lordship.
Here also similar situation prevails.
Similar situation. In fact, what has happened, your lordship, your lordship can kindly come to page 46 first, for a moment, your lordship.
But note, as if we go by the order,
Yes.
the notice was issued on 16th February and the meeting was held on 19th February.
Yes.
So 3 days notice is
No,
there.
your lordship. 17 and 18 will be the two clear days. If the clearest instance, the shortest instance of a meeting, your lordship, under section 17(3) has to be at least on the 20th and not before that. That is our submission. Your lordship would kindly see that the aspect of confidence being lost and regained, it's a matter of time and persuasion, your lordship. Those 3 clear days which have been given to us by the act, because I was the elected president of the Gai Panchayat, thereafter I happened to lose the confidence. If I had been given that minimum 3 days as mandated by the act,
You would have had chance of horse trading.
may have had a case. No, in fact, no.
Yes.
Persuade, your lordship. Persuasion and time.
All
That's
right.
what
All
I
right.
rely on, your lordship.
Yes.
Yes.
Hmm.
And which was not given.
Did you raise this objection? You were present in the meeting.
I was
Did
present
you,
in the meeting, your lordship.
did you raise this objection that no, the notice falls short of the requirement of section 17?
that was not put forth.
So the learned single judge says that that is a waiver. Let us read section 17.
Yes, Your Lordship. Section 17(3). Section 17(3), Your Lordship will have to first refer to section 15 clause 1.
Yes.
15 clause 1 says no confidence motion against the president and vice president. The second paragraph states that such a meeting shall be convened specially by the secretary. Thereafter, if Your Lordship can kindly come to section 17 clause 3. 7 clear days notice of an ordinary meeting and 3 clear days notice of a special meeting.
Right.
Construing, reading the provisions of both the sections, I'm entitled to at least 3 clear days prior to which the meeting should have been held, which was not done in the instant case.
So why should the date of notice not be counted? Where is the proceeding pertaining to notice? Let us see.
Yes, Your Lordship. Your Lordship, the notice at page 55. Page 55, Your Lordship. There's a typed copy.
So there are judgments on 15(1) where the notice was not served, but the president was present in the meeting. Supreme Court says in Padmini Singha, that is waiver.
In fact,
the same situation.
Yes, in fact, I've had 2 Supreme Court judgments to cite, Your Lordship. The fact is, a no confidence motion is to the prejudice of the person who is undergoing that.
But what do you say to lawyers laid down in Padmini Singha?
Yes, Your Lordship.
Read.
Yes, I do not have the judgment now. That judgment squarely does not cover our, it's not.
Without even having the judgment in your hand.
The Padmini Singha, we have gone through the matter, Your Lordship.
So that is a case of notice of 15 days not being served.
It is stated that the time period is not fatal to, that was what was stated.
It was a case of non-service of notice.
Yes.
The court held that once the president was present in the meeting, the issue of service would not render the proceedings or vitiate the proceedings.
Yes.
So the same way,
yes,
the 3 days notice was not given, all right, assuming, but you were there, you did not raise any objection.
that objection was not raised.
Then,
yes.
So meeting is held on 3rd day, assuming that it is a 3 days notice. So why can't the meeting be held on 3rd day? Read from General Clauses Act. You're not prepared, gentlemen. Come back with the better preparation.
Yes, Your Lordship.
List after 2 weeks as paid by land council. Appellant.
Wait, please, Your Lordship. The issue involved in this case is the appellant against him, my lord. In a case, my lord, provisions of that SC/ST Act of 89 was sought to be, added, my lord. Then, my lord, we got to know that the girl in respect of whom the allegation was made, my lord, she can't be an scheduled caste, scheduled tribe. So, my lord, the matter was complained before the competent authority. Eventually, my lord, it so turned out that the state level committee constituted in terms of the Madhuri Patil's decision came to a conclusion that this certificate was, wrongly obtained. Now, Your Lordship knows in para 13, subpara 14 of Madhuri Patil, in fact, my lord, there is one additional affidavit where I've annexed the judgment, my lord. There's an additional affidavit filed by us where we have annexed the order in Madhuri Patil. If Your Lordship,
So we'll come to that. What happened thereafter?
Now, yes. Now, my lord, in terms of subpara 14 of para 13, if the certificate was obtained as a result of obtaining any fraud or anything, then my lord, disciplinary and criminal proceedings should be initiated.
All right.
So, my lord, the mother of the girl was the superintendent of police. And it was at her instance, my lord, all these provisions and all were sought to be added.
Added
Therefore,
against you in some criminal case?
Yes, in some criminal case.
All right.
Then, my lord, we filed the writ petition before the learned single judge. Our prayer was, my lord, in terms of subpara 14 or para 13, government should take some action because it is mandatory provision. Now, my lord, the learned single judge, just one observation, if Your Lordship would kindly come to page 272 of the memo of appeal, my lord. Paragraph 30.
30.
Yes, 30. As can be seen from the discussion made in the foregoing paragraphs, the provisions of 89 Act have not been added to the all-women station case, and as such, regards of the provisions of 89 Act were not felt by the petitioner. This is also not correct. the further STP certificate issued to the daughter of the respondent number 6 was cancelled. This court is of the view that as no legal or fundamental legal right of the petitioner has been violated and there is no existing enforceable right of the petitioner, writ of mandamus cannot be issued to the respondent for initiating any criminal departmental proceeding against the petitioner. Now, if your lordship would kindly permit me to place that paragraph at page 301. 301(14), my lord. In case the certificate obtained or social status claimed is found to be false, the parent guardian candidate could be prosecuted for making false claim. If prosecution ends in a conviction and sentence of the accused, it could be regarded as an offense involving moral turpitude, disqualification for elective posts or offices under the state or union or election or to any local body, etc. Now, what had happened, my lord? This letter, if your lordship would kindly come to page 253, that's the letter based on which, my lord, this certificate was issued. Once. 253, my lord. This was the letter based on which, my lord, the certificate was issued. Lordship may kindly come to the second subpara. It may kindly be noted that the judgment passed by the Honorable Supreme Court of India in Ramesh Bhai versus so-and-so, wherein it stipulates that children of single mothers can take on the caste of their mothers if such a child is brought up by the single mother or belongs to scheduled tribe caste and is treated as a member of the community to which the mother belongs and faces the same deprivation handicap as other members of the community. This is all right.
Right. We have probably heard a similar matter argued by you.
Yes.
Yes.
In view of the above facts and circumstances,
Yes.
I therefore request you to kindly do the needful to issue a caste certificate in the name of my children, Divyana A. Lahan and Ayang A. Lahan, as belonging to STST. See, my lord projected the case that though she is married to a non-STP, yet she was born and brought up in the traditional style. That's what. And that finding, that is not the finding, my lord. Finding is otherwise. The finding of the state level committee, if lordship would kindly permit me to place that paragraph, my lord.
But whether that cancellation, Mr. Chaudhary, whether the
cancellation.
cancellation of the certificate is not challenged
No.
by them?
No, yes, there is one dispute, my lord. In fact, my lord, there was one wrong statement on our part. Earlier, there was a writ petition filed by them. But I have been given to understand, my lord, that writ petition was withdrawn. Subsequently, my lord, we find from the reply filed by them, they have filed a writ petition.
They have filed.
After filing of the writ appeal.
So let that writ petition be decided first.
No, my lord, our prayer was very limited. My lord, during the pendency of the case, we have filed a representation before the government. My lord, despite pendency of this, government may dispose of that representation, my lord.
No, but if the writ petition is pending, supposing that writ petition comes to be allowed and a certificate is granted, then the entire controversy would assume a different complexion. So let that writ be decided. What is the number of your writ petition?
My lord, it is WPC 8024 of 22. In fact, I have filed an affidavit today where I have annexed that order at page 387.
Order?
Issuing of notice, my lord.
Notice.
Notice. In fact, my lord, the appellant has already appeared in that matter. They have filed wakalat number on 1-22.
The controversy
shockingly
revolves. Just hold on. All right, we understand now. The controversy in this appeal revolves around consequences of cancellation of the ST certificate issued to the respondent number
6.
Respondent number 6.
Respondent number 6 is
daughter of respondent.
Daughter of respondent number 6. This court is apprised that the order of cancellation has been challenged by filing writ petition number
8024 of 20.
8024/24. Thus, it would be apposite to wait for the outcome of the said writ petition before considering this appeal on merits.
My lord, can I make one small prayer, my lord? Whether learned single judge can be requested to dispose of the petition, my lord. We'll also file an application.
Well, they have already
The
filed.
parties are at liberty to seek early disposal of this writ petition.
Deeply obliged, my lord.
Deeply obliged.
consideration of this appeal is deferred by 8 weeks.
Okay. Leave your right.
We have sent notice. We have taken the steps to it.
So obviously that SC certificate has been cancelled. Till that certificate remains in that. That point we assist.
Yes.
May I please, Lordship? Lordship, this is a rate appeal against the order of a single judge, honorable single judge, and the subject matter of the case is that it was a managing committee of Yunus Ali High School. It has applied for the provincializations of the employees on the strength of the document of land, which is forged as per the grievance of the petitioner. So, Lordship, we have taken steps today. On last occasions, we are asked to take steps on the respondent number 5 to 14, and accordingly, we have taken steps, Lordship.
This is for admission, not the service is already complete or what, Rupam? This is coming up in which category? Fresh admission. Notice served. Notice is already served. You are saying notice has not been served on which respondent?
Lordship, I have been
5 to 14. There is a report of the office regarding service. No steps taken. Why then? Wrong category. The matter has been listed wrongly under the head of admission notice served. The Land Council, Mr. Bhuyan states that he has taken steps for effecting service on the response numbers 5 to 14. Await return of notices for 4 weeks.
Obliged.
Very hot.
We have filed our affidavit, but here the same problem lies.
Same problem?
Same problem lies.
No confirmation.
Confirmation is under process, they said.
Under process.
They said.
What is the rate of detention?
24, 8, 2022.
We'll have to impose, we'll have to grant compensation.
On 8 of October 2022, the advisory board report has come, and thereafter it is.
Gentlemen, in this case, we'll award compensation then. Every minute's detention is illegal. Read the act.
Yes, I have. The advisory board report, I got an email, if Lordship.
What is the recommendation of the board?
Board has recommended for detention.
Confirmation.
Confirm.
Okay.
Lordship. It will be there. On 8 October 2022, the last 2 pages, it starts at the last 3rd page. I got an email, I took print out. That's why.
What are you referring to?
The report of the advisory board. The last 3 pages, report dated 8/10/2022.
What is the date of the order?
Date of the order is 24th August 24/8/2020. It is
within 11 weeks.
Within 45 days, no?
Yes.
On 45 days. But the confirmation under 9F, it is that they said that it is under process. It is not the order.
The order becomes illegal, or the detention becomes illegal on the face of it. Your detention, initial detention can't be more than 3 months. B says, 9B says the reference, the advisory board has to consider it and give its report within 11 weeks.
Within 11 weeks.
Yes.
It is done.
Then
now after 9F.
Yes.
9F says in every case where the advisory board has reported that there is in its opinion sufficient cause for detention of a person,
yes,
the appropriate government may confirm the detention order and continue the detention of the person concerned for such period as it thinks fit.
Yes.
Maximum period is 1 year, my lord, as per section 11, my lord.
That is only if you confirm the order.
Confirm.
Without that, there is a provision whereby which says that the detention can't be more than 3 months. Just hold on. We'll find out. Constitution देना. Article 22.
Article 22.
Constitution of India.
25 plus one, not also.
Article 22.
Lordship.
(22)(7). Parliament may by law prescribe the circumstances under which and the other class or classes of cases in which the person may be detained for a period longer than 3 months under any law providing for preventive detention without obtaining the opinion of advisory board.
Lordship.
You obtained the advisory board's report,
Lordship.
so it can't be more than 3 months.
True, my lord. True, my lord.
Read 10.
Yes.
10 of PIT and DPS.
Yes, my lord. Section 10, cases in which the and circumstances under which persons may be detained for longer period than 3 months without
Yes.
obtaining the opinion of the advisory board.
Yes.
The
You file an affidavit tomorrow.
Lordship.
What has happened to the confirmation? Then we'll take a call on that.
Lordship.
Learned Government Counsel, Mr. Nath, frankly concedes that he has been informed regarding the order of confirmation of the petitioner's detention not having been passed till date. He shall file an affidavit of the authority concerned by tomorrow.
But
Forthwith file an affidavit of the authority concerned. Retaining authority on this aspect. List affidavit of the retaining authority. List tomorrow.
Lordship.
You also come out with judgments on this issue.
Lordship.
Yes, Lordship, I'm having this assessment.
You're having
Yes, Lordship.
on confirmation.
No, Lordship, not on.
Then-
On the other points, Lordship.
Why do you need to go on other points?
Yes, Lordship. Highly please.
Which one? बुलाइए करेंगे तो नहीं ना. Let's see. Tomorrow.
Tomorrow, my lord.
You need to put them, send them to training.
Exactly.
Call the NCB officers. They are experts.
Exactly, my lord. In all cases, this is the difficulty we are facing.
They'll not, in view of what we have seen, there will not be a confirmation order in any of your detentions. And unfortunately, we have not taken care of that.
But it is, even if confirmation has come, it is beyond
3 months.
After 3
Can't
months.
be. Just
Lordship.
the moment 3 months period is over, the detention is
Detention.
vitiated.
Detention. True, my lord.
Yes.
Honored.
Highly please.
Where is Mr. KL?
Out of the 5 cases listed, 4 are covered by the effects of judgment.
On what aspect? On what
But
point?
the issue was that if the incriminating materials are not found, then the 153 notice, A notice cannot be issued.
Cannot be issued.
Now, tribunals come to a specific conclusion that no incriminating materials were found, and thereby 143(53)A was notice was set aside and the assessment notice was set aside. On the last occasion, my lord, when the KL appeared, he said that we should await for the decision of the apex court. Now the decision of the apex court is there. my lord.
Is there?
That's it.
Where is Mr. KL?
Lordship, I have informed him, he is still in court number 9, your lordship.
Okay. We'll post it in the next week. Mr. KL is reportedly busy in some other court. List, standing counsel, Mr. KL, list on 17th.
So bulky petition, my lord. I am obliged, my lord.
Yeah, they know. 28 to 31, all on 17th.
I'll seek a lordship indulgence, my lord. I was very sorry. I was on the way, my lord, on matters of call, my lord. I'll seek my lord's indulgence for a moment. Item 35, my lord.
What have you done? You adjourned it. That has been adjourned now.
My lord, it would be very humbly, my lord, it will be very fatal for us, my lord. My lord will fix it at the next date, my lord. Next week, on a date, my lord. I was on the way, my lord.
Date on
at least the
24th. We can't help it, sir. Nobody comes
No, but
and
I
you are
was-
expecting the court to wait for you or what?
No, I was on the way, my lord. Just.
Oh, right. So we should keep a tab.
No, my lord, just for a moment. It will be fatal for us, my lord. It's a 2020 matter, my lord. Very short matter.
Oh, wonderful. You are so worried, then you should have been prepared and you should have been in the court. List on 23rd.
Very good. Obvious, my lord.
हाँ, बुलाइए, बुलाइए। Is this in that contempt matter? Definitely. Yes. How's Mr. Mishra now? Okay, okay.
If required, he will come down tomorrow physically or through virtual.
No, whatever. Yes. Hmm. Yes, Mr. Chaudhary. Take your time, take your time. There is no big deal of hurry in this matter. Yeah, there is no big deal of hurry. You take your time. These are not matters to be taken up with any kind of haste.
Lordship, I'll try to make out a case on behalf of the prosecution.
Yes. Terrorist gang and terrorist act, two things.
Terrorism, but Lordship, let me start with the FIR first.
As you please, as you please.
It all starts with the FIR. Now, Lordship, as has already been placed, 1/4/2009, 2 vehicles were seized.
Intercepted.
Intercepted. And this is on GS Road. Some say, Lordship, that they would like to say that it is near Borapani, but the prosecution says that it's
GS Road.
GS Road, Jorapat, Lordship. If I may take your Lordship to exhibit volume 1, page.
You're referring to the FIR?
I'm referring to that.
Yes, we are already having it.
Yes, Lordship.
Yes.
Starts at
Exhibit
page-
30.
Yes, Lordship. It starts at page 61. I'm reading page 63. With reference to the above, I beg to report that on the basis of specific source information, today, on 1/4/2009 at around 4 p.m., vehicle number A01AH Scorpio and A01L so-and-so Tata Sumo were intercepted at 14th mile, and on search of the vehicles, the following persons suspected to be cadres and link pen of DHDJ organization were found occupying the vehicles, and from their possession a sum of rupees 1 crore. 1 crore is an issue here. 1 crore meant for purchasing sophisticated arms and ammunition to wage war against the state, as well as to carry out the nefarious and illegal activities, along with 2 pistols and other documents, including blank letterhead, so and so were recovered. Now, Lordship, what is the case made out in the charge sheet? After the filing of this, I'll come to the recovery. I'll refer to the witnesses and the statements, Lordship. But what is the case in the charge sheet, Lordship?
First, let us see what is the case in the FIR.
Lordship.
Let us read the FIR once again.
Yes, Lordship.
See, you read the FIR n number of times, it gives a different complexion. Read the FIR. Tell us from the FIR, from which vehicle the cash was recovered. This is an FIR coming through a police officer,
Yes.
right? Not a layman. From
Yes.
which FIR was the cash recovered? From which FIR were the letterheads recovered? From which vehicle?
From the
And
FIR,
which of the accused was present in which particular vehicle? Even say that. Let's see.
Lordship. For that, I will refer to the statements, Lordship. From here, Lordship.
FIR.
FIR, Lordship.
So the first observation, the FIR is perfunctory on the face of the record.
Lordship, I cannot go beyond this because
That's a writing, that's a written document.
I will humbly go with the Lordship.
And one more thing, Mr. Chaudhary.
Lordship.
What gave Maizuddin Ahmed the power to distinguish between the driver and the occupant of the vehicle?
Lordship.
How were the drivers, though this was never argued,
It was not.
how were the drivers kept as witnesses and the occupants made the accused? What is the basis of that?
Lordship.
Your source information you have not produced. So
Lordship.
for all we know, the drivers may be a part of the DSDJ. Right? So what is the basis for Maizuddin Ahmed to make a distinction between 2 occupants in a vehicle? One is driving and the other is sitting.
Lordship.
The person sitting may be a gratuitous passenger for all we know.
Lordship. Lordship, if we go a little bit ahead, Lordship, with that.
Oh yes, carry on. Keep that in mind.
Yes, yes, Lordship.
Yes.
In fact, I would be coming to that.
Oh. No evidence. What do you want?
This the Caesar at Lordship, the next page. Sees the articles, but it does not, Lordship, I will humbly admit, Lordship, it does not say from which vehicle what. Now, Lordship, if I may take your Lordship to the 313. Babu's Temple. Volume 4. Volume 4. Page 870. Lordship, I take your Lordship to paper book volume 4, page 875.
Yes, please. We are reading what?
875 is the 313 examination of Babul Kemprai, who was occupying
Babul Kemprai.
Babul Kemprai. He
Right.
was in the second vehicle.
873.
It starts at 875.
You see, Mr. Chaudhary, the principle underlying a criminal case is that the prosecution has to stand on its own legs. That's a fundamental principle. You can't rely upon discrepancies in the defense case.
No,
First, you have to establish your case.
here is an admission, Lordship.
Yes, read.
Here is an admission.
875.
875, I would refer to page 878,
Yes.
question number 11.
Yes.
PW 10 also testified that on search, they found 2 pistols in a briefcase and other papers in the Scorpio, and 1 airbag containing huge amount of Indian currency in the Tata Sumo. And both the vehicles were seized. PW 26 Sri Sudhakar Singh, additional SP, headquarters Guwahati, also testified the same fact. PW 113 Dipankar Dekha. Dipankar Dekha is the driver of the
This
of the
question,
Scorpio.
this
No.
question is very interesting, right? Testified.
Flush.
They proceeded to Jorbat area and from 3 to 14 mile GS around 12:30 PM. Right, sir?
Flush.
Now you come back to your Caesar memo. What is the time of Caesar? Read the FIR. Your fabrication of documents. Read the
4 PM.
How do you reconcile this?
Lordship.
Yes. Can you even make an attempt to reconcile this?
It's on record. I cannot go. But let me.
I tell you, Mr. Chaudhary, every single reading,
Yes.
repeated reading of this
It gives-
FIR gives entirely different.
Yes.
Yes, all right, carry on. So what is the admission?
I was not aware of exhibit 388, but it's not correct statement. This 388 is a statement given by the Dipankar before the magistrate. It is a fact that huge amount of Indian currency was found inside the Tata Sumo, so and so. But I did not carry the bags with money as the vehicle was going without passenger. Therefore, on the request made by Pojendra Hujai, Lordship will continue.
Yes.
On the request made by Pojendra Hujai, contractor, I boarded the vehicle at Ganeshguri after cancelling my
All right,
program
yes.
to go to Haflong.
So confession of one accused, can it be read against the other accused in the same trial? 1964 Supreme Court 1132.
Lordship.
Read. Hari Charan Kurmi. This is a wrong question, which the question should have been disallowed. You can't. The confession of one accused cannot be read against another. And 338 is what? 338 is a statement of that Dipankar.
Lordship.
Oh, and that too a police statement.
No.
Yes. The 161 statement. The magistrate statement given before magistrate.
Yes, Lordship.
What is the substantive value of a statement given during investigation, sir? The person has been examined on oath.
Dipank, no, Lordship, he has not been brought in, Lordship.
He has not been examined.
And he has not been brought in the
Evidence.
as the PW. Lordship.
What do you say? He has been. Mr. Chaudhary need better preparation. Dipankar Dekha, they read the statement. Mr. Burgoyne read the statement in court. He's probably the last witness, if we can recollect. PW 113, the question itself says, "Kya karte ho ji?" But now the trial court, the question which has been put is not regarding his substantive statement, regarding statement he gave to the magistrate.
Yes.
That is just
Lordship.
a trash. That is a trash,
Lordship.
worthless piece of paper. Once the witness has been examined, previous statement cannot be referred.
Lordship. Now coming to the Lordship, charge sheet. What is the case against the
Yes. So, Mr. Chaudhary, once the witness has been examined, his previous statements are absolutely of no use. So this question is of no worth at all. It need not have been answered even. And even if it has been answered, the statement of one accused under section 313 cannot be used against another accused. Even a confession, judicial confession can't be used. That is what the law as laid down by Supreme Court is.
Lordship. But so far as Lordship, the recovery of the amount, it may not
Yes.
be a material against the accused number 1.
Yes.
But so far as the recovery of the amount is concerned, Lordship, that is not disputed. Lordship.
All right, amount is recovered.
Lordship.
What offense does it create?
Yes, Lordship. Now, Lordship, before going into the statements, Lordship, let us see on the what provisions the accused have been convicted, because if we go by all these, Lordship, we need not go. In fact, what are the sections under which he has been convicted? Only that would be material for us, because other.
Can we first keep those lines of your PW 150 in mind, Mukesh?
Lordship.
That yes, I did not investigate this case in light of any terrorist act. Right. So your own IO says, I have not made any investigation regarding any terrorist act in this case number 1/09.
Yes.
So if your star investigator says
Lordship.
no evidence of terrorist act, keep that in mind and now read the judgment.
Lordship.
Conviction is for what offenses?
Yes.
Read, please.
Lordship will find that at paragraph 480.
480.
480 of the.
That is sentence.
He has been convicted and sentenced.
Oh, that is a sentencing part.
Yes, Lordship. I'm on the.
Come on the conviction. Sentencing. First you come on the substantive conviction.
Because other sections, Lordship, they have been acquitted.
Oh.
Other sections, they have been acquitted, and only under, so far as Pojendra Hojai is concerned, 120B and 17. Mohit Hojai, 120B and 17.
Just hold on. Sorry, sister, there is one more thing. How can the conviction and sentencing be at the same time? How could the trial court have heard on sentencing before convicting them? Read. Course, read page 299, para 475. Where is the finding? Where is the conviction before that? First, the conviction has to be there, then the hearing on sentence. Where is the conviction recorded? Mr. Burgoyne.
My lord, I kept it for my other part, my lord. What is that?
Oh, gentlemen.
My lord. Yes, conviction and sentence, your lordship.
This by itself vitiates the entire judgment on the face of it.
Yes, my lord.
We need not even go an inch forward.
My lord. Your lordship.
He has heard the accused on sentence before convicting them.
My lord, your lordship will kindly see, even if we go at 1878, though it is, your lordship is correct. But on the first page.
You don't need your certification.
No, 1878, my lord. The recording is date of judgment is of 22/5/7 and date of sentencing is on 23/5/2017. It is recorded.
Para.
Kindly come to page 1878.
A paragraph of the judgment.
There is no initial.
Initial 23/5.
23/5.
Yes. And where is the conviction? Where is the judgment initial on conviction?
My lord, conviction.
my lord.
Para 480.
Para 40.
No, है ना 472 is the conviction. ऐसा मत करो भाई.
Sentence starts from 475.
Arey, gentlemen, conviction is at page. That is why Mr. Chaudhary confused us.
2164.
Mr. Chaudhary, the conviction is in para 472.
2164.
We are going by
Yes.
paras of the judgment.
472, my lord.
Yes. I thought what he has done. Then the part of hearing on sentence starts.
Yes, Lordship.
472, read. You were referring to what offenses the accused have been convicted.
Lordship. We are concerned with Phojendra Hojai, Mohit Hojai, and Joel Garlasa for the moment.
Yes.
Phojendra Hojai 120B and 17. So, Lordship, whatever they have been charged in the other sections, they are acquitted of those. So we have to concentrate only whether a case.
17, read 17.
Yes,
Come.
Lordship.
Read 17. We'll reassemble at 2.
Yes,
Mr. KL, what, in pursuance of this judgment, what remains in your 4 of your appeals go?
Lordship, some grounds is there, Lordship.
All right, we'll hear you in the next week then.
Lordship fixed on 17th.
Yes.
Lordship, it may be on 18th.
18. But you are not supposed to ignore division bench
No, Lordship.
for arguing before single bench.
Since morning, Lordship, matter was going on. That's why I could not appear, Lordship.
Okay.
On 18th, I will make my summary.
We'll resume it.
Will be entitled to open the NIT, and in case the respondents have applied, their bid will be considered as per the eligibility and in accordance with law. We hope and trust that the petitioner will also ensure the project is completed as per time fixed. The petitioner will nominate a nodal officer who will be held responsible in case of any delay and default. My lord, today we got the communications that headquarter has appointed the nodal officer, that is ED Kohima, my lord. But I got the soft copy, so it will be. I will request that Lordship let me be given a time. Within a day, I will file an affidavit. What we have done, my lord.
All right, now we are not, since the order has been stayed, we need not even proceed any further in this petition. We'll just put it in abeyance. We'll keep the petition in abeyance. What else?
May it please your lordships.
Yes, please.
If my lords may kindly appreciate this fact.
Yes.
Preparation has been made and a direction has been made that the contract process, the fresh NIT tender that is floated, we have been allowed to participate, lordship.
Yes.
And now, lordship, we have already applied, but because of some technical problem, we could not upload it on the day on which we were supposed to post it. My lord, the representative, the respondent number 14's representative is there before your lordships. So if my lord may kindly get some feedback from the representative of the respondent number 14.
Respondent number 14 regarding sections 1 and 2.
No, package 3, my lord.
Package 3. But package 3 now we are not at all entering into that issue because the order which we passed has been stayed by Honorable Supreme Court. Let the things take the usual course in terms of the NIT. Whatever follows, we will follow. What else we can do? We are not delving into that issue now. Mr. Burgoyne has placed on record copy of the order dated 1/5/2003 passed by Honorable the Supreme Court, whereby the order dated 31st March 2023 passed by this court, effect and operation of the order dated 31st March 2023 passed by this court has been stayed in view of the above development, it is hereby directed that further that this the consideration of this suo motu PIL is deferred sine die. Yes.
My lords, if it pleases the court, my lords, I want to make a small humble submission, my lords.
Yes.
My lords, on the last occasion, I had presented myself before this honorable court.
Yes.
And informed this honorable court about the payment that was to be made to me. My lords, there are 2 documents that I've submitted with the learned court master. My lords, there is a letter that has been transmitted.
You file your application, whatever, Mr. Arora. You file your application, we'll consider it. You don't throw across the documents.
No, yes. Lords, it's nothing to do with this matter at all, my lords. It was only in compliance with the order of this honorable court.
Yes.
I had submitted a bank guarantee. My lords, now NHIDCL was to release those monies. My lords, unfortunately, in the original order of my lords on page 8, my lords had mentioned that I will submit a bank guarantee to the tune of 7.5
Arbitrator,
crore with
to the arbitrator. Okay.
with the arbitrator. Now, my lords, the only difficulty is in my bank guarantee, it categorically states that same to be released by the order of the tribunal, but submitting with the tribunal was a difficulty, my lords. I've already done that. A letter has been transmitted by Delhi NHIDCL to Kohima to release the monies to me, but the court is to be apprised that there is a slight divergence from the order. If my lords permit, then my lords, they will release the monies. The difficulty is, my lords, I was out
Mr.
of
Burgoyne,
pocket for 11 months.
Is there any difficulty in releasing the money to the contractor now?
My lord, just I had a telephonic conversation because I have received these documents just now, my lord, to be very frank. So let me go through the papers. I cannot say because just now I have received.
Mr. Arora, if you find any difficulty, you move an interlocutory application, we'll consider it. But right now, you've just given this document to Mr. Burgoyne. He will instruct his clients accordingly.
Because even I have got some documents from my client, my
My
lord.
lords, the only my only humble submission, my lords, is if that divergence is allowed by my lords, then I will.
What is
move
the
an application. My
divergence?
lords,
What is the
what
divergence?
fell from my lord was that I should submit this bank guarantee in favor of the tribunal. My lords, that usually is something that is a little.
We didn't say that it in the name of the tribunal. We just said that the bank guarantee would be submitted in the tribunal, but in whose name to prepare, we have not clarified. So you could have done it in the name of the NHIDCL.
That's right, my lords. If my lords may just kindly clarify this, my lords, they are just finding it difficult to, my lords, comply with the orders in that case. My lords, nothing else. He'll just put the matter to a coitus, my lords. Otherwise,
In reference to the, further to that, Mr. Mayank Arora has drawn the court's attention to the communication dated 9/5/2023, which indicates that there is some incongruency in the matter of releasing, in the matter of the bank guarantee submitted by the respondent number so and so, by the contractor, which is causing some confusion for releasing the amount of rupees, the amount, 10% amount in terms of the order dated so and so passed in IA number so and so. We hereby clarify that the bank guarantee, which was required to be submitted to the sole arbitrator, is to be prepared in the name of NHIDCL. That is what you want? Shall be
yes,
prepared in the name
already
of the
been done. It's already been verified, my lords. Yes, my lords.
in the name of NHIDCL and may be submitted to the arbitrator thereafter.
I am most grateful, my lords. I am most grateful.
Directed the director of the respondent number 4 to personally.
In view of the preceding facts, the direction given. What about the respondent number 8?
Lordship, I am presenting respondent number 8.
Yes.
The director was personally present yesterday, but
All right, we have seen that.
he is.
But what about the pending works?
We have completed the pending works.
My lord, I have not received any instruction to.
We will file our affidavit.
And counsel, Mr. So-and-so, representing the respondent number 8, submits that the director, managing director, was present yesterday, but the matter could not be taken up. He further makes a statement that the work on packages numbers 1 and 2 has been completed. The authorities of the NHIDCL may verify such statement. The petition is adjourned sine die for being considered as and when required at the Kohima bench. If so required at Kohima bench. Okay.
For that matter, if you realize, how do we confront the witness with the FIR? The first information. FIR is a witness. It is nothing but a previous statement. So the same treatment is to be given to the 161 statement.
Yes. UPAPA Act, Act is here. Yes.
Lordship was section 17 of the UAP Act, Lordship.
Yes.
Whole one, of course.
Oh, of course.
Finally, punishment for raising funds for terrorist act.
Mm.
Whoever in India or in a foreign country directly or indirectly raises or collects funds or provides funds to any person or persons or attempts to provide funds to any person or persons, knowing that such funds are likely to be used by such person or persons to commit a terrorist act, notwithstanding whether such funds were actually used or not for the commission of such act, shall be punishable with imprisonment, which shall not be less than 5 years, but which may extend to imprisonment for life and shall be liable to fine. Now, Lordship has to see, because here is not a case where the accused is himself accused of killing somebody. It is here a case where an organization is involved. The case is of an organization. So whether the organization has in fact.
Is it, be specific,
Lordship.
is it an organization?
Lordship.
Organization is defined under the schedule.
No, Lordship, it is.
Terrorist organization,
Lordship,
if you go
it
to
is-
that, then it has to be under the schedule.
If Lordship.
And there's no doubt that as on the date of this incident, the DSDJ was not a declared terrorist organization.
Lordship, that plea was taken up in the case of RH Khan, is also one of the accused before the Honorable Supreme Court. And the Supreme Court has the Supreme Court has not Lordship entertained that plea, Lordship.
Maybe that was maybe for quashing.
Lordship.
For what purpose was the petition filed?
It was for bail, Lordship.
Bail.
Bail, Lordship.
Oh, that's a matter of moment. Interlocutory orders.
Lordship.
Herein we are called upon to answer whether there is even a charge of terrorist organization.
Lordship.
Is there a charge of DSDJ being a terrorist organization?
No specific.
No. So then
Collection of fund, Lordship.
collection of fund. Now,
Lordship, we have-
all right, read about collection of fund. Collection of fund for indulging in a terrorist act.
activity, Lordship.
Okay. So now who is obviously for proving this allegation, you will need substantive evidence. Right? Someone has to come and say that this was the fund which was collected for the purpose of is a terror funding kind of thing. So who is the witness as per you? Best witness, your star witness. Then, give it your best shot. Yes.
Lordship, here nobody says directly that it is for terrorist.
Which fund are you referring to? First, let us know.
Here, Lordship, what has happened is the money has been siphoned off from government agencies. It has been routed. It has been converted. That has been used for purchase of weapons. So
just hold on, sir. You say that money has been siphoned off. Is there a charge? There was a charge here. But has anyone been held guilty of siphoning money from the government funds?
Lordship,
if so, please read the finding.
Lordship, not held guilty, Lordship, but the siphoning, how it has come. That is, of course, Lordship, evident from the statements given by Lordship.
Before going to the statement, read the finding. That would give us an idea what statement is to be referred to, which is the finding in this regard. Who siphoned of the funds?
Lordship.
And then did Joel Garlosa receive any part of that fund?
Lordship, right now I'm not on Joel Garlosa, Lordship.
Okay.
Joel Garlosa will come later on. First, the fund has to come, then it goes. Because
Obviously.
Joel Garlosa is accused of being a member of the DHT. Now, fund. Because the fund has to be generated, then it has to be siphoned, Lordship. The fund lordship is lordship, if I may take your lordship to the statement of PW 51, 53.
53.
How gradually it has been. 51 lordship will find volume 2, page 402.
Dilip Fonglod, Dilip Burman.
Lordship.
Yes, we have it. 140. Yes, read.
Mm. 51. Lordship at page 402.
We are having this station.
Dilip Fongla. In the year 2004, I was doing Amway marketing business at Haflong and was residing at Haflong. During my Amway business in the year 2008, I came across one Biraj Chakraborty as UDA in PHE department, Haflong. As I told him of my financial difficulty in the business, he told me that he has got a known engineer by the name of Karuna Saikia. Karuna Saikia is also accused here, Lordship, who was working in the PHE Haflong, and he can help you. After some days, Biraj Chakraborty took me to the said engineer at Haflong Bazaar and introduced me to him. I told Karuna Saikia regarding my financial difficulty and asked him to give some work, to which he agreed, and he told me to give my mobile number to him, and he assured me that he will get in touch with me. After 3-4 days, I met accused Karuna Saikia in Haflong Bazaar. There he gave me a supply order of rupees 3,000. He starts with supply order of 3,000 for supply of nuts and bolts to the PHE department. Accordingly, I supplied the materials and received payment, making a profit of 500 rupees. Accused Karuna Saikia told me that whenever there is work, he will inform me. After about 15-20 days, Karuna Saikia rang me up and told me to meet him at Haflong Bazaar. On meeting him, he told me that there is a profitable work and he will give it to me. On 31/2009, accused Karuna Saikia called me and told me to meet him at Haflong Bazaar. He handed over a check of rupees 20,99,500, which was in my name, and told me to encash the check from the bank and hand over the cash to Mohit Ojai. Mohit Ojai is accused 3 lordship, CEM. He told me that the money is required for getting fund, and he promised that after this he will give good work. Accordingly, I withdrew the amount from the State Bank of India, Haflong, and handed over the cash to Sri Mohit Ojai. Exhibit 229 is the said check. So is my signature on the reverse side of the check. On 2/2/2009, accused Karuna Saikia rang me up and asked me to meet him at Haflong Bazaar. On meeting him, he gave me a check which was in my name for rupees 10,50,000, and similarly asked me to withdraw the amount from the bank and hand over the cash to Mohit Ojai. Accordingly, I took the check from the accused Karuna Saikia and encashed the amount from SBI Haflong and handed over the cash to Mohit Ojai. Exhibit so and so is the check, so and so is my signature. I handed over the aforesaid cash to Mohit Ojai at his residence at Bolidura.
Was any official from SBI examined?
SBI lordship
So
of
he just says this is a check.
check.
Whether there is a corresponding evidence of cash withdrawal, the relevant registers or the bank entries, are they available?
That is. Achha.
We'll have a look at this check.
Lordship.
221 then, with check check is
Exhibit,
exhibit
exhibit 221. Right, 229,
229. Give it, please.
229. And 230. Exhibit.
Account opening form has been proved. But whether those
230.
account details are there.
Page 229,
Exhibit 229.
1064.
Whose check is it?
1064. This is lordship issued by executive engineer PhD. Lordship will find at 1064.
That's it. Executive engineer PhD. Karuna Saikia. He is the issuing authority. Who issued it?
Lordship.
Hmm?
And money he has collected and he has given it to Mohit Hojai.
That is what he says, obviously.
And next is also lordship 1066. Excellent. Now,
and that too from a government account.
Is there any corresponding evidence? This is a check from a government account. The cash could have been withdrawn. 20 lakhs.
I believe your lordship was not dealing in Mohit.
Who is dealing with Karuna Saikia?
yes, he has already expired.
Oh, he has passed away. Okay.
Periods of my lord, in general, my lord, these are banking documents, my lord.
Hmm.
As per the Evidence Act, this has to be accompanied by the Banker's Book Evidence Act certificate.
No, that's not the issue. But we are asking whether any bank official has come to depose regarding these withdrawals or any entries of withdrawal.
One thing is that, my lord, this is related to NIA case number 2, my lord. Because in cross-examination it was written down. I have no knowledge about NIA case number 1/2009.
But this has been exhibited in one, na?
Yes.
That is the problem. This is exhibited in one. The mark of exhibit is 1/9.
9. But he was a witness of NIA 2, 2009. In the cross-examination, it has come up. He is a witness of NIA 2 of 2009, and he himself has a CBI case.
On that he said that I am an accused
Yes.
in a CBI case.
So, lordship, let us go.
Continue. Anything is to be cleared, it has to be
Yes,
done right now. No?
yes, lordship.
Now, in the meantime, you please check up whether the corresponding bank entries were proved or not.
My lord.
Check up.
I handed over the aforesaid cash to Mohit Hojai at his residence at Bolidura on 7/2/2009. Once Sriwell Masa, cashier PHE Haflong, rang me up in my mobile and handed over an unsigned check of rupees 12,60,000 and told me to ring accused Karuna Saikia. Accordingly, I rang up accused Karuna Saikia, where he told me to meet him at Lanka. Lanka is a place, lordship, near Haflong, lordship. And there I gave the check, and the accused Karuna Saikia put his signature in my presence on the check and his official seal, and told me to withdraw the amount from the bank and hand it over to Mohit Hojai. He also told me that he will give me a good work for all these works I have done. Accordingly, I encashed the check from SBI Haflong and handed over the cash to Mohit Hojai at his residence. Exhibit 231 is the check. Lordship will find that at 1068.
Now we have seen
I was instructed by accused Karuna Saikia that after withdrawal of the aforesaid amount, from the bank and handing over the same to Mohit Hojai, I was to phone Viraj Chakraborty that I have done my work as was directed by the accused Karuna Saikia. Accordingly, on handing over the amount to Mohit Hojai, I rang up Viraj Chakraborty and informed him that I have handed over the check amount. I have shown the account opening form of my account in SBI with my photograph. I said that the account was opened on 23/3/2007. We can skip this on the next paragraph. Later on, I heard that Viraj Chakraborty as well as accused Karuna Saikia were being questioned by police. And I realized that I have been used by Karuna Saikia for some illegal purpose. I did not get any supply order as promised by accused Karuna Saikia, nor did I submit any bill for any work to the department. Regarding the above incident, I have also made statement before the magistrate under 164. Today I have seen the statement. I say that I have stated the same to the magistrate. Exhibit 234 running pages 5 is the statement. Let us see, Lordship, what Mohit Hojai in his cross tries to get out or what he has actually got out. The cross of Mohit Hojai, Lordship, I am reading. He says, I was never a contractor, but I was doing network business. He already said that he was doing some Amway business, Lordship. I only knew accused Mohit Hojai, and I had no acquaintance with him. He was at that time CEM. I never worked as a contractor in the PHE department Haflong. The check given by accused Karuna Saikia for the amount to 20,99,000 only to withdraw the amount, and the check was issued in my name. I was asked to hand over the said money by Karuna Saikia to accused Mohit Hojai, but I have not taken any receipt or acknowledgement from him. At that time, there was none with me. Likewise, I have not got any receipt or acknowledgement from accused Mohit Hojai for handing over 10,50,000 on 2/2 and 12,60,000 on 7/2/2009. Earlier, I deposed in a CBI case. In that case, also I exhibited and deposed regarding the checks dated so and so. In that CBI case, I was an accused. It is not a fact that I was made an accused in the CBI case as because I encashed the aforesaid 3 amounts and misappropriated myself and have not handed over to accused Mohit Hojai. It is also not a fact that the NIA officials asked me to depose to the effect that I handed over the said 3 amounts to the accused Mohit Hojai. I deposed accordingly in the court. It is not a fact that to exonerate from the CBI case, I deposed falsely. Now, Karuna Saikia, Lordship, because Karuna Saikia issued the checks, the same page, Lordship, will find 405. I do not know the number of the case in which I am deposing. I am under metric. I was never a contractor of PHE, nor I have any registration. I do not know how I get the supply order of ₹3,000 for supply of nuts and bolts. I do not remember the mode of payment of ₹3,000 for the supply of the above said materials. I knew Viraj Chakraborty from earlier because he used to take Amway products from me. I do not know as to how the checks payment of contracts works are paid to the contractor, as I have never been a contractor. He said, I have never been a contractor. It is not a fact that I have some personal link with Srivel Masa. It is not a fact that the checks were given to me by Srivel Masa. It is not a fact that in connivance with Srivel Masa, I siphoned off money from PHE. I do not know whether there is any official record of the checks which were given to me by accused Karuna Saikia.
This is the question.
Yes, Lordship.
Which has a material bearing.
Lordship.
Official record would include the record of the PHE, Aflong and the bank, both.
Lordship.
So where is the corresponding official record? The expressai doesn't seem possible that the bank would encash a 20 lakh rupees check issued by the executive engineer of PhD. Carry on, anyone?
Yes, Lordship. I'll try to find it.
Yes, yes, you try to find out, yes.
Now, Lordship, next I would refer to
53,
53, Lordship.
yes.
53 is at page 409. Uttam Phanglosa. Today I have appeared before the court on receipt of summons from the court. Presently, I am working as UDA in the district library, Haflong. Somewhere in the year 1991, I opened a firm by the name of Munna Phanglosa. It was a proprietarial firm and I was managing it. In 2008, I met Biraj Chakraborty, who was working in PhD department of Haflong. He introduced me to one Karuna Saikya, the same person, who was an engineer working in the PhD department. I requested him to give me some supply order to maintain my family. Accordingly, I received small supply order from the department in the year 2008. In the month of January 2009, Karuna Saikya gave me 2 checks in the name of my firm, Munna Phanglosa, for rupees 21,45,000 dated 31/2009, exhibit 235. 235(1) is my signature on the reverse side of the check, and another check of 20,55,000 dated 31/1/2009. Exhibit 236 is the said check. Exhibit 236(1) is my signature on the reverse side, and asked me to deposit the said checks in my account and withdraw the money and give it to CA Mohit Hojai. Initially, I objected to it, but I was put to fear by Karuna Saikya that he will file complaint against me. Then I agreed and went to bank and encashed the amount from my account. Exhibit 237 is the said check by which I withdrew 41 lakhs on 31/1/2009. Exhibit 237(1) is my signature. 237(2) is another check. On the reverse side of the check is another signature on the reverse side of the check. And after coming out of the bank, I met Biraj Chakraborty and another person whom I did not know. Biraj,
So right, we understand. Your case is that in this manner, the funds were siphoned off and were given to Mohit Hojai. Where does it lead to? It leads to defalcation of government funds. All right. To that extent, maybe we may accept your version. What thereafter?
Lordship, at this stage, it may seem defalcation. Let's.
Of course.
Lordship.
Come forward. Come,
Yes.
move forward.
Lordship.
Presume that we have already put you the query.
Yes.
Where are the banking transactions corresponding to these checks?
Yes, Lordship.
You will have to show us those. Because the question which is coming forward is, where is the receipt? The bald Dixit of this man that I handed over the money to Mohit Hojai, whether that will be acceptable.
Now, from Mohit Hojai, where the fund has gone,
Yes.
we'll come to that, Lordship.
Yes.
On one. PW 50. PW 50. Five zero. Also, 397. Lordship, may I take your lordship to
L. Nangmai.
lordship? PW 50. Lordship.
Senior Finance and Account Officer and Sales. Yes,
how the money is coming from the
yes.
authority, Lordship. Today I have appeared before the court on receipt of the summons from the court. During 2009, I was working in the NC Hills Autonomous Council as Senior Finance and Accounts Officer. I have been working in the council from 2007 as in charge Senior Financial Officer and full-fledged so-and-so from 2009 till date. My receipt memo dated 15/6/2009. I have handed over 14 files belonging to the PHE department. These are mostly related to the PHE and the what was the other department? All right. Belonging to the PHE department and social welfare department. Transfer order and joining report so and so. This lordship can skip. I will take your lordship to the next page. At page 60, 61, and 82 to 87 of exhibit 217 are letters from Hill Areas Department Dispute, Assam, regarding release of funds to NC Hills Autonomous Council for implementation of planned schemes during 2008-2009. Exhibit 219 is the file so and so regarding release of funds work maintenance to the executive engineer PHE Maibong division. At page number 3 regarding requisition of release of funds amounting to so and so has been processed and put to me proposing release of funds mentioning the availability of provision of fund under, this is the head lordship, water supply and sanitation. Accordingly, I put up the file to the principal secretary mentioning the availability of fund provision. This should have been position lordship, in which I have quoted to the authority the weakness position of the personal ledger account. However, the then principal secretary recommended to the Honorable CM for release of fund to amounting to rupees 50 lakhs to Umrangso division, PHE. Thus, the Honorable CM released 90 lakhs. Now, the fund position was bad. 50 lakhs ought to have been released, but 90 lakhs released. Similar other circumstances are there. I'll come. At the relevant time, Sri Mohit Hoja was the CM. By PLA account, it means that all funds received from the government of Assam for the departments are deposited through by transfer bills and challans. From the said account, PLA account, the money required for the other department are released. At page 4 of the note sheet, an amount of 4 crores 49 lakhs 11 so and so has been processed for release against the implementation of water supply and sanitation program of Maibong division. Accordingly, after checking the proposal note of the dealing assistant and accountant, I have put up to the principal secretary mentioning the availability of fund provision under concerned head of account and also mentioning the absence of financial sanction of the council. The then principal secretary put up the recommended 50% of the requisition amount to the Honorable CM. The Honorable CM released 1.84 crores and 25 lakhs under ARP scheme at page number so and so to the note sheet. The dealing assistant and accountant put up the requisition to release rupees 2 crores 40 lakhs and odd, mentioning release of work under this account. However, no action was taken. Exhibit so and so are the relevant provisions of the note sheet. Exhibit 2196, 2197 are my signatures. And exhibit 2198 and 2199 are the signatures of the CEM, Mohit Hojai, and exhibit 21910 are the signatures of the principal secretary, A.K. Barua, which I identified. Exhibit 220 is the file number so and so regarding release of fund for maintenance to executive engineer, PHE, Umbrangso division. At page number 3 of the note sheet, an amount of 1 crore 20 lakhs only was proposed for release under this head. I have put up the file before the principal secretary mentioning weakness position of the PLA account. The principal secretary recommended for rupees 50 lakhs and the CM released 95 lakhs. At page number 4, an amount of rupees 4 crore 30 lakhs only was proposed to release under 2215 SWS for procurement of GI pipe and payment of original work. I put up the file mentioning overall balance of the fund to the department. The principal secretary recommended release of less than 1 crore. However, the CEM released rupees 1.29 crores. Exhibit 220 /1 and 220 /2 are the relevant portion of the note sheet. 223.
So the statement of this witness is that the CM released excess funds.
He has been releasing excess
funds,
funds.
right. Read the cross-examination.
Cross-examination. Lordship, Mohit ho jaye, I'm reading. At page 401.
Yes.
I exactly cannot say the tenure of Mohit ho jaye when he was CM of NC Hills Autonomous Council. The financial year begins from April to 31st March next year. The principal secretary is the chief officer of the council, deals with PLA accounts of the council. Sri A.K. Borua was the principal secretary from 1st April 2009. Money into all departments under the council are deposited under PLA account. In certain case, CEM approves more money than recommended by the principal secretary when there is enough money in the PLA account. All such files dealing with sanction and release of money were returned to our section from the office of the CEM. Though the office of the principal secretary, through the office of the principal secretary. It should be through lordship. But I cannot say the exact time when I came to know about the sanction and approval of the same by the CEM. But I only come to know when the files reach the financial and account cell. I did not inform anybody officially that the CEM enhanced the amount which was sanctioned by the principal secretary. I cannot say who was officiating as CEM from 2009, January 2009 to June 2009. That money, excess money has been released. That is not disputed, lordship.
Where did it reach is the issue.
We gradually lordship of the other accused because they are in the line. Lordship, may I take your lordship to the deposition of PW 78, that is a volume 2, page 483.
Biraj Chakraborty.
Biraj Chakraborty, because they take the name of Biraj Chakraborty.
Yes.
PW 78, lordship, at page 483.
Yes.
In the year 1981, I joined as LDA in town committee. Thereafter, in 1995, I was transferred to PHE Haflong. In the year 2009, I remained as UDA in PHE department for the release of funds, etc., from government to the PHE department. I had come to Guwahati and get the work done. In the month of January 2009, Mohit Hojai CEM called me to his chamber and gave me a piece of paper containing some name and asked me to take it to Karuna Saikia, who was working as in charge additional chief engineer for placing order in favor of those persons who were in the list. I remember the name of two persons. They are Munna Honglosa and Dilip Honglosa. We had just read the. After some days, Sri Mohit Hojai again called me to his chamber and told me that he had some discussion with Sri Karuna Saikia and that Karuna Saikia has handed over checks to Munna Honglosa and Dilip Honglosa. And as directed, I had to take the boy to bank as indicated by CEM. There was a boy accompanying CM, Sri Mohit Hojai, and after encashing the check amount and hand over the amount to the boy who was authorized to receive the amount on behalf of Mohit Hojai. Thereafter, again I was called by Mohit Hojai and directed me to take the same boy who had gone earlier to the house of Jibangsu Paul for collection of some money. Accordingly, I took the boy to the house of Jibangsu Paul, who I know. As scheduled, the boy went to the house of Jibangsu Paul and came out carrying a polythene bag containing something. Thereafter, the boy went away and I came to my house. Sometime thereafter, Karuna Saikia talked me over phone and asked me whether Dilip Honglo had met Mohit Hojai or not. Thereafter, Dilip Honglo, some word is missing. Thereafter, I met Dilip Honglo near the bus stand and asked him whether he has met Mohit Hojai or not. And he told me that he met Mohit Hojai. In this regard, I made a statement before the judicial magistrate, so and so. Lordship, cross of Mohit Hojai. I am an employee of the PHE department, but I am not an employee of Mohit Hojai. Sri Karuna Saikia was my immediate superior at that time. I have never worked under the office of Mohit Hojai. During my employment in the office of Additional Chief Engineer and CLs, I was once arrested by police in connection with Deung Mok PS case number 3 of 9. This case was later handed over to NI and the same was numbered as NI case number 2 of 2009, the other case lordship in this. Ultimately, during and after investigation of NI case number 209, no charge sheet was filed against me and I was cited as a witness by the NIA. The slip of paper about which I mentioned in examination in chief, claiming that the same was given to me by Mohit Hojai, has not been produced in the court today. In that slip of paper, there was no signature of Mohit Hojai. Mohit Hojai became the CEM of NC Hills in the year 2009. I cannot recollect when for the first time Mohit Hojai called me to his office. Mohit Hojai did not personally introduce the boy referred by me to me. And I also did not know the boy from earlier. Since Munna Phanglosa did not know that boy, I took the boy to him and introduced him to Munna Phanglosa. I do not know what was inside the bag which was given by Munna Phanglosa to that boy. Thereafter, I cannot say where the boy went with the bag. I do not remember the date when Mohit Hojai called me for the second time. The boy came to my office and along with the said boy, I went to the residence of Jibangsu Paul. I was at the gate and the boy went inside the house and came back with a polythene bag. Thereafter, I do not, one word is missing. Thereafter, I do not know, it should have been, where the boy went. I deny the suggestion that Mohit Hojai never instructed me to take the boy once to Jibangsu Paul and on another occasion to the bank to meet Munna Phanglosa. During my employment in the concert department, I never gave anything to Mohit Hojai. And I recorded my statement with connection with NI case number 2, my statement so and so. Now, what transpires from this is lordship. Money, some money was being siphoned off by giving some checks. Let us assume for the timing till my documents come up, lordship. The checks given because PW 51 and 53 categorically states that some checks were given, they had encashed it, given the money to Mohit Hujai. Biraj Chakraborty also says, he goes a step further, there was another boy who, according to him, Mohit Hujai asked him to take to the bank, and that the boy went on the instructions of Mohit Hujai. He has categorically said that I deny the suggestion that Mohit Hujai never instructed me to. So there were some transactions, money was coming. Now we'll go to the next. I would take your lordship to PW 92. So 92 is lordship volume 3, page 526. Volume 3.
92, then volume 2.
Volume 3.
Page
526, lordship. Now, yes, lordship. Has lordship got it? 526. I joined PhD department Haflong in the year 1983 as junior engineer, and I retired on 28th February 2015 as assistant engineer. As assistant engineer. In the year 2008-2009, I was working as assistant engineer and assistant executive engineer in rural subdivision, Haflong. In PHE department, Exhibit 312 is a bill of Mrs. Ma Trading, Haflong, for supply of, this should have been galvanized, GI pipes dated 26/2/2009 for rupees 14,99,780. On the reverse side of the bill, there is a verification to the effect that the bill is verified and found correct. And the materials received in full and good condition. Exhibit 3121 is my signature. However, the verification was given by me under pressure from KB Mukherjee, executive engineer, who pressurized me to verify the bill immediately, and materials may be given by the party after few days. Exhibit 313 under objection is a letter dated.
This is 8/162.
Yes, lordship.
Both are 8/162. All 313, 314. So you need not even bother reading this.
Lordship.
So all that the witness alleges is that he signed the verification under pressure of that gentleman, KB Mukherjee, who is that
he is the executive engineer.
Prosecution witness. Okay.
94. Now, I would take your lordship to the evidence of PW 35, which my senior friend has already referred to earlier. EW 35.
Imdad Ali.
Imdad Ali.
इसमें है हाँ वो ऐसे चलाओ ना यस
Lordship. At 282, Lordship. I was in NC Hills from 1994 to 1999. I was a contractor in PWD and I worked for construction of roads, bridges, buildings, etc. From 1996 to 2000, Prasanta Varisa was the CM of North Kachar Hills Autonomous Council. Thereafter, Punendu Lavithasa was the CM from 2001 to 2006. And from 2007 to 2008, Dipolal Hojai was the CM. For my construction work, I received payments, but small amounts remained with the council, which I could not recover. When I was in NC Hills, I came to know Jayanta Kumar Ghosh. Jayanta Kumar Ghosh is also an accused here, Lordship, who is also known as Dhruva Ghosh. He has a hotel in Lower Haflong railway station and he had business of railway catering business. Since then, I came to know J.K. Ghosh, that is Jayanta Kumar Ghosh, Lordship. I became friendly with him. In 2008, I carried an amount of 15 lakhs from Guwahati to Kolkata. I carried an amount of rupees 15 lakhs from Guwahati to Kolkata to be given to Jayanta Ghosh. Accordingly, I gave this amount to J.K. Ghosh. The said amount of money was carried by J.K. Ghosh and was given it to somebody and has given it to somebody. I do not know. And I was along with him, but I was in the car. Then I returned to Guwahati. In 2009, Dipolal Hojai resigned as CM and Mohit Hojai became the CM. Mohit Hojai rang me up and told me that he wants to send some heavy amount of money to Jayanta Ghosh at Kolkata and whether I could help him in sending the amount. He also told me that the money is sent through Marwari and whether I know the procedure. As I was at my village in Hojai, I told him that I do not know any such person who could help him sending money from Guwahati to Kolkata. After about some days, I happened to meet one Didar Ahmed Chowdhury, who is known to me, and he told me that Mohit Hojai has taken his help in sending rupees 80 lakhs. I do not know the exact amount.
What is the worth of this statement?
Lordship, here, Lordship, if we go further, Lordship, all the witnesses, Lordship, a transit of the money is made through J.K. Ghosh, through Bob. So, Lordship, there's a link to it. I'll come to that because it goes via this person's Lordship.
Assuming for a moment, where does it lead to the terror funding?
Lordship,
To come to that straight off. We assume what you are arguing is correct. A lot of money was siphoned from the NCL's funds. Assume. It was sent through Jayanta Ghosh to Kolkata. Mohit Ojai instructed that it should be sent.
Lordship,
There were huge defalcations.
Lordship.
Then what? Come to then. Where is the terror funding act angle to this? Defalcation
No.
for illegal gratification for gains, human greed.
Lordship will allow me to go in my village.
We are just facilitating you. We
No,
assume
no,
that what
because-
you are arguing
no.
is made out.
Yes.
Okay.
Here, no, what Lordship,
Your ultimate objective is to satisfy the court that these funds were used for terror funding, procuring weapons.
Lordship.
So now come to that.
Lordship, because the other with, the accused are directly related to that, Lordship. First, let them open them.
Terror funding, the other accused are not related. Terror funding arguments have already been made. And they have straight up said that there is not an iota of evidence.
Lordship, I'll come to that. Lordship will allow me to go in my.
Very well,
Lordship.
very well. Okay.
I have thought it in a particular line, Lordship. Let me.
All right. Will not disturb your line of thought then. Carry on. Yes.
Lordship, I'm very sorry if I have.
No, you can have your own way of arguing.
Lordship.
You were just trying to
I'm trying
facilitate your arguments to be limited a little bit. By saying, by for a moment assuming, of course, we are not closing things very soon.
Lordship.
But we just want to know what is the line from which you can connect this money to terror funding. Where is that thread or the chain of circumstances which can connect, assuming we said that yes, all right, assume.
Lordship.
These are witnesses whose evidence is reliable that all these defalcations were made. Nothing new about it.
Lordship.
Defalcations are rampant in n number of government departments.
Yes.
Would that by itself give rise to an inference that this money was subsequently used?
Lordship.
For any illegal purposes? All right, you do it your way.
I'm at page 283, Lordship. In the latter part of January 2009, Mohit Ojai again telephoned me and told me that he was to send some money to Kolkata, money at Kolkata. I told him that I am in Delhi in hospital. As such, I will not be in a position to help him in sending such money. I have given my statement before the police NIA regarding the above incident. I have also given my statement before the SDGM Kamrup, and the same was recorded by the magistrate. Today, I have seen my statement before the magistrate, that is Exhibit 97, is the said 164 statement. Exhibit 98 is the check amounting to rupees 20 lakh, which I had given to J.K. Ghosh, because the J.K. Ghosh will be creeping up in every stage.
His statement is very categorical. That amount was withdrawn and deposited in the IRCTC. So that is a valid business.
Now we'll come to the other parts also.
Yes. His statement doesn't take you anywhere.
Now, J.K. Ghosh and cross for J.K. Ghosh is in the next paragraph. I married to Dilwara Begum, her father's name is so-and-so. He used to be an MLA of the Congress party in Assam from Jamunamukh constituency. He was an MLA during the period so-and-so. We are 4 brothers. Their names are Ibrahim Ali, Ahmed Ali, Rashid Ali. I'm in the construction business from the year 1992. And I run the said business in the name of Imdad Ali. I have petrol pump in the name of my wife. This business of petrol
Come
pump.
to the relevant
is-
part. Why you are reading the entire thing? Come to the relevant part you want to rely upon. He find even from his chief, other than a bald aspersion, that Mohit Ojai contacted him for sending the money He never acted as a courier. He never acted as a conduit. Only conduit is for sending money to Jayant Ghosh.
Jayant Ghosh.
That's all. Who
Lordship.
sent that money? He doesn't say that who sent that money.
No.
He said that I carried money on my own
Lordship.
and gave it to Jayant Ghosh. He deposited it in IRCTC.
Lordship.
So what is the incriminating part of his statement? And who he incriminates other than Jayant Ghosh?
Jayant Ghosh.
As per you, he incriminates Jayant Ghosh.
Lordship.
All right.
He's coming into the picture, Lordship.
All right. Read cross-examination by Mohit Ajayi. I have not seen any handing over of any money to Dildar Ahmed Chaudhary by accused Mohit Ajayi. So far as Mohit Ajayi is concerned, his evidence is zero.
Lordship.
Yes. Now,
Lordship, so far as terrorism is concerned, DHT and triangle of terror is concerned, Lordship, I would take your Lordship to the deposition of a few witnesses.
yes, sure. That is what we are looking forward to.
Volume 1. No. It only 24. EW 46, Lordship.
46.
EW 46, your Lordship will find volume 2, page 378. Volume 2.
Then away.
Volume 2.
Mm. 378.
378, Lordship.
Yes.
Is marrying Dola Gupta. He says, I joined DHD in 1995. This is a militant organization led by Joel Garlosa, who was the chairman of the.
Is there a difference in militant terrorist, militant organization and a terrorist gang? You have to be very specific. Militant organizations may be many.
Lordship.
They may be against a particular line of thinking. That's a different thing.
Lordship.
But can they be branded to be terrorist gangs? All right, carry on.
Lordship.
And he talks of DHD. Your charges of DHDJ.
I remained with this organization from 1995 to 2003. The militant organization was operating in Karbi Anglong and NC Hills, now Dima Hasal. The arms and ammunition required for the operation of the organization were purchased locally, and we used to get it from Bangladesh. In the year 1995, I went to Bangladesh as was directed by the organization DHD. I remained in Bangladesh for about 3 months. I went there and set up a base for the organization. I went there to set up a base for the organization, but could not set up the base because of financial problem. So I returned. I do not know the source of Bangladesh. In organization, chairman was Joel Garlosa, vice chairman was Dilip Nunisa, commander-in-chief was Pranab Nunisa. Our militant camps were always on mobile, and cadres used to move so the arms and ammunition were received at different places. On 1st January 2003, ceasefire was declared between the militant and the government, and around 300 cadres, including me, on signing the ceasefire agreement, we shifted to the designated camp In October 2003, the organization was separated. And Joel Garlosa went and formed another militant organization by the name of DHDJ. In the year 2006, when I came to liaison office, Dibarai, Haflong, to meet Dilip Nunisa, and on my return to my camp at Arangajal, on my way, I was attacked by Daku Singh, alias Ethan Haflongbar, and another person belonging to the group of DHDJ. On this attack, I received 6 bullet injury from AK-47 rifle. I was badly injured. Thereafter, I was airlifted to hospital and admitted to GMCH Guwahati. I remained in the hospital under treatment for 3 months. Accused Joel Garlosa is present in court today.
All right.
So,
Okay, assume.
organization is formed. He was fired upon.
Organization he knows about is DHDJ only, DHD only. He only says he has a fictional thought that Joel Garlosa set up another organization named DHDJ. Okay, he has never seen the activities of that organization DHDJ. He doesn't say a word about what were the activities of DHDJ. It's true?
Lordship, but there's a firm statement, if I may repeat, Lordship.
Yes.
In October 2003,
Yes.
the organization was separated and Joel Garlosa went and formed another militant organization by the name of DHDJ.
Militant organization.
It is not figment, Lordship. It's a categorical statement.
All right. He says that he formed it. What happened thereafter?
Lordship will come to the next sentence.
Yes.
In the year 2006, when I came to liaison office, Dibarai, Haflong, to meet Dilip Nunisa, and on my return to my camp at Harangaja, on my way, I was attacked by Daku Singh, alias Ethan Haflongbar, and another person belonging to the DHDJ. In this attack, I received 6 bullet injuries from AK-47.
Who person? Which person? The vague statement. Absolutely. Daku Singh, whether he's connected with DHDJ, he doesn't say. And who is the other person? That is why it's a fictional statement.
Lordship is referring to the second person.
So he only says the second person is from DHDJ, not Daku Singh.
Lordship will read it once again, Lordship.
Yes, please. Sure, sure. Not once, twice, if you say. Read. I was
attacked by Daku Singh, alias Ethan Haflongbar. It doesn't end there.
Yes.
And another person belonging to the group of DHDJ.
So you mean to say that DHDJ governs both?
Both.
All right.
On this attack, I received bullet injury from AK-47 rifle.
Okay.
Now let's see the cross form.
He says my statement was not recorded by NIA. So whatever he's saying is for the first time coming into the court.
Lordship.
Why should we believe such a person?
Lordship, it may kindly come to the second sentence.
Yes.
My statement was not recorded by the NIA. It is not a fact that I did not state before police that I joined DHT in the year 1995. It is not a fact that I did not state before the police that this is a militant organization led by Joel Garlosa, who was the chairman.
Yes.
It is not a fact that I did not state before the police that I remained with the organization from 1995.
That is what the, if you want to be same law of the defense is they were required to confront. If they wanted that these are improvements, then they have to point it out from the statement. Unless it is exhibited.
Yes.
So 161. It is
because
it is not a fact that I did not state before the police.
Document which is not exhibited, it gets shifted to part B of the file, which is not recorded.
Yes.
It is not a fact that I did not state before the police that I remained with the organization from 1995 to 2003. It is not a fact that I did not state before the police that the organization was operating in Karbi Anglong and Sindhis, now Dima Hasao. It is. It is not a fact that I did not state before the NIA that the arms and ammunition required for the operation of the organization.
No, it's all denial mode.
Law.
It's all denial mode. Yes.
Therefore, Lordship, one thing.
Tell us from the statement of this witness that DHDJ is involved in terrorist act. How do you infer that fact?
I'm coming, Lordship.
Read.
Not
Not from this witness.
I'll come to that.
Come to the next witness, whatever you say. And here, Ms. Defense Counsel, same fault. You are referring to the previous statement, but you don't exhibit it.
But at that point of time, this particular, I must say, I came into this trial in this matter.
After this cross-examination was. Is there 161 statement of this person? Is it available on record?
Yeah.
There is no 161 statement of this man.
Yeah, it is there. But the paperwork, it is not exhibited by the defense, by the cross-examination. Same mistake.
Same mistake. That's what we are saying.
Because the moment, as a student of law, the moment a witness says that I have not given a statement before the NI, then the should have been stopped.
Yes, precisely.
Precisely. But by doing the other.
Now you are trying to draw parts from that statement.
Exactly.
And the statement is not before us.
Same mistake. Same mistake.
Yes.
161 is there.
Where is it?
The Lordship will find that volume 7.
Where now volume 7?
Page 1799.
Let's see. What has he said there?
May I read it, Lordship?
It's a disastrous kind of trial. 145 has two parts. First part is when you can cross-examine the witness orally in reference to that particular statement. But once you want to refer to the previous statement, then that has to be shown. Shown in court means exhibited in court. Without being marked as an exhibit, it is not shown.
Lordship, this how it has to be done has been laid down way back in 1959. I have the judgment, Lordship.
There is no need of a judgment. 145 is itself a full code in itself.
Yes. And that has also been Lordship reiterated in a division bench judgment of this honorable court.
Yes.
Lordship, page 1799. I was an original member of DHD in 1995, along with Dilip Nonisa and others. Our president at that time was Joel Garlosa, alias Mihir Burman. He used to organize training for the cadres and procurement of arms. All demands for money from contractors, sawmill owners. So that time, Lordship, those.
There's all any
there.
Statement we can't read.
The arms were mostly procured from Bangladesh. That he says here.
And then there is a fundamental error in this investigation. The statements were given by the witnesses in Hindi. The IO records them in English. Yes. Anyhow, so this statement will not refer. It's not exhibited. We'll not even read the statement. Next statement, what you want to refer?
Lordship, PW 23, Lordship. Volume 1, page 77.
Kulendra Dolgopu,
This was also referred to by my senior on the other side.
Yes.
In the year 2002, I was a member of National Commission for Youth, Government of India. I had resigned from that membership in 2004 and joined in active politics. I contested unsuccessfully from 16 half-long LSC in the year 2006. Again, I contested in MAC election 2007 and won and elected to the NC Hills Autonomous Council. And subsequently, I was appointed as executive member EM in charge, medical and other departments. But after resignation of Vipul Ahuja as the CEM, the executive committee got defunct. This is defunct in the month of November 2008. I also contested in the MP election in the year 2009, but I was defeated. I also contested so-and-so, it's not relevant.
What
I
violent,
know
what violent activities he refers is based on newspaper reports. Hearsay evidence, not even hearsay. Worse than that.
I was in the second paragraph.
Yes, that is newspaper reports,
Lordship,
not his personal knowledge.
Lordship. Then I take your lordship to PW 20 at page 68.
Ronsling Langthasa.
He was declared hostile.
Yes.
Let's see the first paragraph. I was a cadre of DHD of NC Hills for about 16 years. From the year 1996, Joel Garlosa was the chairman, Dilip Lunisa was the vice chairman, and Pranab Lunisa was the commander-in-chief. From 1/1/2003, DHD group entered into a ceasefire with the government. After ceasefire, Joel Garlosa continued with the organization. He suddenly disappeared. We do not know where Joel Garlosa went thereafter. We thereafter made Dilip Nunisa our chairman to continue our organization, and till this stage, the said group worked and finalized the accord in October 2012. Joel
So
Garlosa,
DHD is not an illegal organization. You now recollect that witness, earlier one. So as long as Joel Garlosa is a member of DHD, there is nothing wrong, right?
Lordship.
Because this organization has ensured the peace accord.
Lordship.
And now you come to the next page of this witness, cross for accused Babul Kemprai. That should be enough to satisfy the court that his previous statement, though not exhibited, even if it had been exhibited, had no value whatsoever. One police officer in police uniform interrogated me, asked me, I do not know English language. I did not make any statement in English language before an IA. So what is RO and AC?
Lordship. Here I was, I leave this apart, Lordship. Here I was just relying on two sentences at page 69 and one at page 71. Because since he has turned hostile, other things will go.
What statement, what part you want to apply?
Lordship will see the third paragraph.
Yes.
I also deny the statement that in that I also deny the statement at that time in 2005, Joel Garlosa did not have a big strength. So he had a strength. It is in the negative. And in the last page 71. Second paragraph, Lordship. It is not a fact that Joel Garlosa was not associated with the DHT.
DSD, all right.
Yes.
DSD is a lawful organization as per this witness. The entire charge is on DSDJ.
Lordship.
They are happy if you establish the association of Garlosa with DSD. They are quite happy with that.
No. No.
Ask them. Yes, Mr. Borgoin. Will you be happy if they say that the Joel Garlosa is member of DSD? No J. They'll be overjoyed.
J for Joel.
Yes.
Lordship. Then I would take your Lordship to the deposition of PW 24. This also my senior had referred. At page 81 of the same volume, Lordship.
24. Volume.
It's in volume 1. Volume 1.
It's not there. No. What's the name?
Amitabh Sinha.
Amitabh Sinha. He is your star witness. Let's appreciate it. He is the one on whom trial court says, yes, the man Friday for bringing home the charges. Yes, let us see and keep on commenting which part of it is admissible in evidence. Make your comment. So he joins in March 2009. He joins duty in March 2009. So what happened before that? He could not have had any idea.
I joined in March 2009 as additional SP at NC Hills. I continued up to December 2010. NC Hills is presently known as Dimahasa. At NC Hills, I was responsible for maintenance of law and order and crime detection in the area. Immediately after my joining, there was spurt in violence because of DHDJ, there was Naga and Dimasa.
So the ethnic clashes.
Yes.
Ethnic clashes and terrorist activity. It's two distinct.
Perhaps the next Lordship.
Of course.
DHDJ had stopped train services flying from Landing to Badorpur, thus virtually stopping food trains not only in Barak Valley, but also to states like Mizoram, Tripura, and Manipur. DHDJ would resort to firing on the moving train from the hills on both sides of the more than 120-kilometer railway track. This was the situation when I joined. Because of counterinsurgency operation, lots of additional forces were deployed. Things gradually improved, finally leading to the laying down of arms by DHDJ cadres in March, April 2010. But there was always a feeling that an apprehension and some intelligence inputs as well
that all arms and ammunition of DHDJ were not handed over at the time of laying down the arms.
Come to cross-examination. Leave this. Come to cross-examination. Hojendra Ojai and Sandeep Ghosh. Bottom two lines. I have not stated before the IO. So this, yes, in view of this admission, there was no need to exhibit the statement because he admits that he has not said so. So that omission is a fact admitted by the witness, and hence it need not be proved as such from the earlier statement. I have not stated before the IO that at the NCL so and so, so and so. The entire part of his examination in chief was not stated by the witness to the IO during 161. Everything you are reading in the examination in chief is an improvement from the 161 statement. No, you can confirm it from the statement. Take out the statement. As it was not asked by the IO, last two lines in first para, page 4. As it was not asked by the IO. That is why I did not say so. So this is a sheer improvement. And coming from such a senior police officer, it would have a stronger effect. So this was not argued. Again, this was not argued.
Entire this evidence of PW 24, he brought in, he exhibited 4 sets of documents, 57, 58, 59. That happens to be the FIR and the CW.
Yes.
Now, our argument was that as far as the Dixon case, that particular case, the recovery of arms, in that particular case,
Arms, forget about that. That was an open recovery from an open place. No one was there and the FR was given.
that was the first argument.
They are relying upon the statement that DSD indulged in stopping of trains, firing on trains.
My lord.
Regarding that,
No, madam, it was argued. Though it was not dealt with it, madam. It was argued.
argument here in this court that this is an improvement from the earlier version. Ask him, he was there with Mr. Mishra on that day.
Now, very beneficial, my lord. All the recordings are there. Yet,
Is it so?
Yes, yes, yes.
Okay. So you can reconfirm
Yes.
whether it was argued. Yes.
Lordship,
Yes, 161.
No.
Have you found out?
I'm
But
getting.
it is very clear. Read page 4. This cross-examination in reference to the earlier statement starts from page 3, bottom 2 lines. I have not stated before the IO. Then the inverted commas start. And they continue till the last. As it was not asked by the IO, but my role, designation, profile of duties that I am expected to discharge. So this entire part, what he says in examination in chief, is an improvement from what he stated to the IO of this case. And an improvement of this category case, this huge magnitude, obviously has to be discarded.
Lordship. Let's quote it.
So
Let's quote it. So 161.
इसको हिंदी में कहते हैं भैंस पानी में बैठ गई है ना चलिए
हाँ Next, I would be taking your lordship to PW 129.
yes
Dilip Nonisa, lordship will find that at volume 3, page 640. Volume 3.
volume 3 640
At 640, lordship.
yes volume 3 yes
In the year 1990, I was a student leader. In the year 1995, I have joined as a member of DHD group. DHD group. The group was led by the then President Joel Galosa. DHD's objective was to create a separate state for the Dimasa people within the territory of India. I remained with the organization till ceasefire was signed with the government of India and Assam in the year 2003, with effect from 1st January 2003. Our organization DHD worked for general upliftment of the people of the locality. This your lordship can skip.
Why? He is appreciating DSD. He is your witness.
Lordship.
All right.
Lordship,
So DSD has been given a certificate of appreciation by not one, more than one of the witnesses read by you, referred to by you. Okay.
Lordship, I'll read it.
No, carry on. Yes.
I will read it.
Yes.
Our organization DHD worked for general upliftment of the people of the locality and their educational and other rights, and also for their social upliftment. I do not correctly remember that I was interrogated by NIA officials in connection with this case. And I also do not correctly remember if my statement was recorded in connection with this case. Then this witness was declared hostile.
Hostile.
Now, I may take your lordship to that part, which is not contradicted.
Second page, bottom para. That is what you are referring to?
I will be referring to the middle also. One minute.
All right, read.
After the italics, it is correct that during that time, Joel Galosa was a member of the DNSF. It is correct that in the year 1995,
Yes.
1995, Joel Galosa became the president of DHD when I joined the organization.
Yes. All right. So he was the president of an organization which was fighting for the rights of the local people and for their upliftment.
Now, lordship will come to the
Bottom two paras.
bottom two para.
Just after the italics.
After the italics.
Yes.
It is correct that when I became a member, we struggled for our rights, and during that time, I used to remain in different jungles within our district. We go for our training in camps where we were provided by our leaders dummy weapons made of woods. At the time of ceasefire in the year 2003, I was vice president of DHD and I participated in the ceasefire ceremony.
Yes. So the earlier activities have been purged.
Lordship, our organization, lordship, once it is brought under the schedule, that does not, that would necessarily will not mean that after it is put in the schedule, any offense that is done, they will be liable. And organization is put under the schedule because of whatever they have done much before from them. Only for that purpose, it comes.
Is it your charge? Is it your charge that the DSD activities would also bring it within the purview of the terrorist organization?
Lordship.
It's not your charge. Then all right. Now come to the bottom para, which as per you is very important.
Lordship, I have marked it.
Read.
I know Lordship will go to that.
No, that is marked in bold underlines.
Lordship. It is correct that there was a communal clash between the Mar people and the Dimasa people. It is correct that number of Dimasa people lost their life during the clash. It is correct that Joel Galosa separated himself from our organization. It is known to everyone that after the clash between the Mar and Dimasa people, Joel Galosa formed a group called Black Widow, which otherwise is DHDJ.
No, who says so? No, RKD Chaudhary saying so would not work.
It has also fallen from the senior advocate.
That is an argument. We need proof.
Lordship.
We need proof.
Lordship. So,
what thereafter?
Uh,
The DSD group, read page, next page, It is correct that one member, Nirang, our liaison officer, was attacked and he received bullet injury. I cannot definitely say whether it was done by Joel Garlosa or any other group. I cannot definitely say when the group DSDJ came to in existence, but I can say the group existed. The DSD group is led by Joel Garlosa. The fact was known to me and the people at large through media. So the fact that DSDJ is led by Joel Garlosa comes into the public realm by media reports, which is as reliable as it is now. They were as reliable then. Yes. What is the incriminating part in his statement? The fact that he has stated about Black Widow is going to cause you more trouble. Now we'll ask you to link Black Widow and DSDJ.
There was an agreement. So like that is a documented. What story? And volume they go on ballot. That is after this. So then it becomes a band organization. Then we can.
Yes.
I would take your lordship to page 465 of volume 2, PW 72.
Mm. 465. Yes, please.
Is Anurag Tanka. In the month of June 2009, I was posted as Superintendent of Police, NC Hills Haflong. I remained there as SP Haflong up to February 2010, so far as I remember. I received a letter dated 16/6/2009 from DIG NIA, and so seeking some information in respect of ongoing investigation. I replied to the aforesaid letter by my letter dated 20th June 2009, addressed to SP NIA camping at Haflong, wherein I conveyed the requisite information as per the available records. Exhibit 271 is the said letter. 271(1) is my signature. By the said letter, I have conveyed the list of cases with brief in which Joel Garlosa alias Mihir Burman, Partha Varisa alias Asringda Varisa were charge sheeted along with photocopy of charge sheet. Also, the letter contains a list of cases pending under investigation at that point of time in which Joel Garlosa was involved, as well as a case brief of the incident dated 14/6/2009, which occurred at NC Hills Autonomous Council Office. Exhibit 271 to so and so are the list of cases where charge sheet against Joel Garlosa has been filed. Exhibit 271. My letter number so and so, I dated 6/11/2009, addressed to the Inspector General of Police CID Assam. I have conveyed required information as sought for by his office. White memo number so and so dated 28/10/2009. The information relates to certified copies of FIR cases registered in NC Hills district in connection with incidents of snatching of weapon of security forces after being attacked.
Whether that list is actually there? Are you sure?
I have it
271
271.
at page number 1211. That is right. That is the document signed by Anurag Tanka.
Sir.
Read, this is volume 5, part 2, paper book 1.
Five. Here's the volume 5. Volume 1. Two 71,
1211.
one to one.
Read 272 upon 2. Appendix A, and read the contents. Not in a single case is there any reference to either Joel Garlosa or Ashindra Varisa. That was extensively argued by Mr. Mishra. Number of miscreants, then extremist, DSDJ, then it is 11 Umarang so PS case number so and so, unknown extremists. We have the chart. Appendix 1213. Show name of Joel Garlosa in any one of them, or Ashindra Varisa. All extremist unknown assailants.
Not specifically there.
So his statement, as we told you, is nothing but a fictional story. He comes and states in court that these are charge sheets against Joel Garlosa, which is incorrect as per the document. Okay. Yes.
Third paragraph in the page 466. The earlier paragraph, of course, relates to this one. The document judge, now we have seen. The DHT cadres came over from the jungles before the civil administration in batches.
DSDJ.
DSDJ. Cadres came over from the jungles before the civil administration in batches, and two major batches surrendered on 13th and 14th September 2009, and they were housed in safe locations. Subsequently, a formal surrender ceremony was organized at the district headquarters, Haflong, on 2nd October 2009, which was attended by the Chief Minister of Assam, senior officials of the state and district administration. I was present in the ceremony, supervising as the superintendent of police. In the aforementioned ceremony, Niranjan Hojai was the senior most DHG cadres, along with other cadres who had surrendered, who led the surrender ceremony. Today, I have seen Joel Garlosa.
Is there any document pertaining to that surrender ceremony?
Yes, Lord.
On record?
Surrender.
Exhibit.
Lordship, is there? I will. Sure. Then the cross by accused Joel Garlosa and Ashindra Varisa.
Yes.
At that point of time, I was superintendent of police of NC Hills. The letter dated 16/6/2009 by which DIG NIA so and so sought information with respect to the above case is not available in court today. I cannot remember now whether the letter aforesaid as received by me was under section 91 CRPC expressly or not. The state-
Nothing cross-examination,
Nothing, Lordship.
nothing.
And
And in
I would-
cross-examination, it is
I-
clearly there that the cadres surrendered without arms and Niranjan Ojai was not present. That is what the cross-examination on behalf of
Lordship,
Niranjan Ojai is.
the last sentence.
Yes,
No,
last two sentences. It is not
It
a
is-
fact that I was not present in the surrender ceremony. It is not a fact that DSDJ cadres have surrendered without arms. It is not a fact that on the concerned day, 2nd October 2009, Niranjan Ojai was not present there.
Therefore, they surrendered with arms. Lordship
So
will
shows
see.
the document.
I'll take out the ceremony.
Yes.
Sure.
Sure.
I'll take out the. Lordship.
All right.
That. So it says it is not a fact that the GSG cadres have surrendered without arms. that
He
means with
says
arms.
that is
Yes,
the defense
that-
suggestion.
That will take out with the records.
Yes,
Lordship.
yes.
It is not a fact that I was not present in the surrender ceremony. It is not a fact on the concerned day, that is 2nd October 2009, accused Niranjan Ojai was not present, so he was present. That is our case. I will take it out from the
Yes.
surrender ceremony, Lordship.
Right. Okay.
And the other witness that I would be referring to, Lordship, is 126, which my senior on the other side has also referred to, Dipolal Hujai. That is volume 3, page 625.
Yes.
In the year 1996, Lordship has got it 625. In the year 1996, I contested autonomous council election from Wajau constituency and got elected from ASDC. That is Autonomous State Demand Committee. And I became executive member in the council. I remained as such till 2001. In the year 2001, I did not contest election and I was busy in the work of my party. In 2007, I again contested election from the same constituency, from the same party, and got elected MEC. After the aforesaid election, there was an alliance between the BJP and ASDC, and the members of both the aforesaid parties who were elected as MEC elected me as the chief executive member of the council, and I took over as the CEM of the NC Hills Autonomous Council in the month of January 2008 till 26th November 2008. I was CM. On 27 November 2008, I submitted my resignation from the post of CM on health grounds. The first of the argument from the other side that he has resigned on health grounds. Exhibit 96 is my resignation letter to the governor of Assam dated so and so. Exhibit 96-2 is my signature. The letter was forwarded to the governor by so and so. After my resignation, Mohit Hojai was elected as CEM because during my resignation, the council was in session and hence my successor was elected immediately. After resigning from the post of CEM, I, along with my wife, came to Guwahati for treatment. In the year 2013, I contested from the same constituency as an independent candidate. However, I lost. At present, the CEM of Autonomous Council of so-and-so is Niranjan Hojai. In 2008, Niranjan Hojai was in Jungle. In 2008, Niranjan Hojai was in Jungle. I know Joel Garlosa, who is now an elected MEC. He also contested the election into the year 2013 and was elected. In 2008, I do not know where Joel Garlosa was. He has not come to the politics during that time. During the time when I was CM so-and-so, Lordship can leave this point. During that time, when I was the CM, law and order situation of the council was bad. In connection with this case, I was interrogated by NIA and I have given my statement. I do not remember the date. And he was declared hostile. Now, the Lordship will come to page 627, second paragraph. This is not contradicted. The contradiction is in italics. I remember that on 26th November, there was a medical departmental program and I was the chief guest. I also remember that the EM in charge, medical, was Kulendra Dolagupu. Kulendra Lordship we had read some time back. I also remember that after conducting the program, I reached home around 5 p.m. I remember that Bijoy Senyum, Kulendra Dolagupu, came and met me for holding the session of the council. And I remember that I had fixed the session at around 7 p.m. on that day. The meeting lasted for about 1.5 hours to 2 hours. In the said meeting, I decided to resign. The decision to elect the next CM, Mohit Hojai, was taken on the next day. I know Purnendu Lanthasa, he was the CM till 2006. He was killed by extremists in 2006. I remember that he was killed during election campaign by extremists. It may be DSDJ, but I cannot say exactly. I do not know why he was killed. I remained the CEM for 11 months, so and so. Till November 2008, I was never threatened by anybody from any other quarter. Ma'am. Now, Lordship, may I take your Lordship to the cross by R.H. Khan?
Yes.
At page 630.
Yes.
During the governor rule in NC Hills, Deputy Commissioner of NC Hills became the sole administrator and all departments used to work under him. I only know that accused R.H. Khan was Deputy Director of Social Welfare Department of NC Hills, Haflong. Next sentence is important, Lordship. It is true that I shifted to Guwahati only for educational purpose of my children. He did not resign on health grounds.
Shifting into Guwahati is a different part. You did not even cross-examine him on that part. Did you cross-examine him in reference to what he stated, that I resigned on health grounds? Where is your question? Did you controvert this version?
Lordship.
We'll help you out here. There is one part you have missed out, which you can probably hang on to. This double negative has been recorded in the statement at page 67, last bottom para. Read. You might like 627. There is one sentence in double negative. It might help you. Seems to be a typing error, but yes, since you are otherwise also hanging on to.
That I have marked it, the last portion. I have marked it.
That is an apparent error in reference
It is
to
not the fact that I did not state. I have marked it, Lordship.
the statement not being exhibited. It is absolutely of no use. Yes. Next.
PW 62 2 cases. No, Lordship, so far as the connection with terrorist activity, Lordship, basically these witnesses are relied upon by the prosecution, namely 20, 23.
Yes, sir. Read this. Read the definition of terrorist activity, and then tell us which of the witnesses is relevant to prove this charge.
Duty Act.
That's a part of another trial, as they say. Those litigation parts. Yes. Read, please. Error funding. All right. Money was defalcated.
Lordship.
Assuming that you were able to prove it.
Lordship.
Where did the money go?
Lordship.
There are two recoveries which you bank upon, or you have given them up. One Lal Channa. And that
one Lal Channa is to come.
So that is one recovery of weapons.
Lordship.
Which we can at the outright say you miserably failed to link with this case. Because the recovery was made first, the disclosure was recorded later.
It is not under 27.
So it is not a recovery in this case in any event. So that recovery doesn't take you anywhere. What else? Read the statement, read the section. Terrorist Act.
Terrorist Act, Lordship. I'm
This.
taking the whole act. Section
15.
Whoever does any act with intent to threaten or likely to threaten the unity, integrity, security or sovereignty of India.
So let's stop here. That is a part of waging war against the country. That part they have been acquitted. They have been acquitted. It's a specific acquittal.
Yes.
You were not able to prove. And then, or with the intent.
Or with the intent. To
Yes.
strike terror. Or likely to strike terror.
Yes.
In the people or any section of the people in India or in any foreign country.
By.
By using bombs, dynamite.
This is not your case.
This is not.
Death of or injuries to any person, persons, again, not your case. Loss, damage, destruction to property, not your case. Is it? No, correct us if you are wrong. In which part of this A or B?
3.
Read. Disruption of any supplies or services essential to the life of community in India and any foreign country. Which was the disruption? Who has given a,
That is of 24, Lordship. PW 24.
that police officer who we have already read, it's not a part of his previous statement.
Lordship.
Hmm.
And
Conjectures and surmises. His statement is totally based on conjectures and surmises. Next. Damage or destruction of any property.
that is,
No allegation.
that is not.
Now comes B. Overalls by means of criminal force or show of criminal force, public functionary. So here you can say Deepu Lal is I.
Deepu Lal,
He doesn't support you.
Lordship.
So if there is no terrorist act, what is there to fund?
Lordship.
Come to 17 now.
Whoever in India or in any foreign country directly or indirectly raises or collects funds or provides funds to any person, persons or attempts to provide funds to any person or persons knowing that such funds are likely to be used by such person or persons to commit a terrorist act, notwithstanding whether such funds were actually used or not for commission of such act, shall be punishable with imprisonment which for a term which shall not be less than 5 years, but which may extend to
All right.
imprisonment for life.
So
Now,
these,
here-
yes. So these funds as per you were defalcated for the purposes of being used in a terrorist act.
Lordship.
What is the evidence? Where did the funds go?
Lordship.
Tell us, sir. Please.
Lordship, let us see how the funds have gone first.
Of course, of course, of course. Let us see that. Which is the particular fund you are talking of? First, the 1 crore.
1 crore is in treasury, Lordship. That
It didn't go anywhere.
that I can show. That I can show. In fact, Lordship was asking like how it has been deposited. And I found out.
It's lying in cash.
No, it has been deposited in the treasury.
Cash. You didn't get it converted post 8/11.
Dollar.
There is somewhere there was a reference to chalan. Chalan means deposit in account.
That Lordship is.
And where did the 5,000 rupees go? As a convenience fee?
145. Lordship, in fact, that is stated by PW 145. I will.
All right. Okay. So now let us see where the funds go.
Lordship.
Where does the river flow?
Lordship, let us first go to the 1 crore, then.
Of course, of course.
I take your Lordship to EW2.
PW2.
EW2.
Yes.
Chandrakanta Guru. He is at volume 1.
Yes.
Page 15.
What more can he say other than Maizuddin Ahmad? He authorized Maizuddin Ahmad to go
Yes,
there.
Lordship, that, and he, Lordship, he's, in the first paragraph, after getting the information, I deputed SI Maizuddin Ahmed to go to Jorabat, that is in the outskirts of the city, and to inquire about the information. Maizuddin Ahmed came to police station and deposited 1 crore and 2 pistols and other articles after interception of 2 vehicles, which were carrying the above amount, and thereafter he has lodged a formal FIR, which was registered as Vasistha PS case number 170 of 2009. Then on 35/09, the IO D cycle Lordship, that is PW 145. I will come to that. Of Vasistha police station informed me that one accused named R.S. Khan involved in the case is residing at Tarun Nagar, so and sought for permission to pick up the said person for information. Accordingly, I went along with the staff to Tarun Nagar to the residence of R.H. Khan and found him in his residence and searched his house and seized ₹4 lakh from wooden almirah of his house. The cash amount was seized. R.H. Khan was brought to the police station for also interrogation. Thereafter, I interrogated R.H. Khan, recorded his statement, prepared supplementary case diary, and trusted the matter to IO Mr. Saikia, along with supplementary case diary to continue the investigation. By Exhibit 9, I have seized the cash amount of ₹4 lakh in the bundle of ₹500 denomination, phone and all, in cross by Mohit. On 1/4.
What do you want to gain out of the cross? You say what you have gained from the examination in chief of this witness.
Lordship, that the amount was, Lordship, seized from the vehicle.
Which vehicle?
That, Lordship, because that I will explain, Lordship.
And where was it deposited, sir?
It was deposited in the treasury, Lordship. That.
Oh, does this witness say?
No, this witness.
He says that it was given to me.
This
Where did he take the amount? To his home?
The IO deposited it in the treasury. That is.
Gentlemen, when something, a mudda mal, is handed over to the officer in charge of the police station, he is supposed to deposit it, keep it in safe custody of the Malkhana of the police station. And there is a document, there is a register called Malkhana register. Where is that register? And the person who is in charge of the Malkhana is the head Mohrid, who mentor the Malkhana in charge. Where is that witness? When was it handed over to the NIA officials, the amount? Or when was it deposited in the treasury? What is the date?
That I can do.
And in between that, where did the amount remain?
Lordship, okay.
Show us.
No.
He himself doesn't say what he did with the money seized from R.H. Khan. He seized that money. He doesn't say anything. Your police officials in Assam, they have no idea how investigation is to be conducted. With due respect, I can tell you, in Astana, head constable would have done better investigation.
Lordship,
This is terrible to say the least.
Of the records, Lordship, what I may say, in fact, London Senior Counsel on the other side was referring to a case, magistrate, whether it should be judicial magistrate or.
Yes.
He was referring to a case of Anupam Das. And I have got a first-hand idea of that case because my bhanja was murdered, was chopped to pieces, 10-year-old boy. And I have seen it, how investigation goes.
It's terrible, to say the least.
And it so happened, Lordship, if I may say,
Hmm.
while the trial was going on in our sessions court,
Hmm.
he was kept in that cell where this accused persons are kept.
Who?
This accused,
Right.
Anupam Das,
Okay.
he was there.
Uh-huh.
He was neither handcuffed.
No,
The
handcuffing
cell-
is not permitted.
The cell was not locked. Even the police was not there. Police person was not there.
And he escaped.
And he simply walked out
Oh my
in
goodness.
2001.
Hmm.
He committed the murder in 2000. And Lordship, it's such a horrible sight.
Naturally.
I had to put him in pieces to do the inquest. And 2001, he walks out from the cell. Case is registered, no follow-up, nothing. I got some information that he was someplace near this,
How long?
near Haflong.
Oh.
Not Haflong, it's in Karbia.
Hmm.
I informed the police.
Hmm.
And what the police does is, they send a person with a photograph and they inquire in the shop where he was working and he fits through the back door. And ultimately, 2006, because I move around the whole of Northeast and my private cases, that time it was integrated, this High Court.
Hmm.
And I leave some pictures of the accused with my friends.
Right.
And these pictures happen to be left behind by the police. Pictures, some certificates what happens is when a person appears in a matriculation in compartmental, his photograph is attached to the admit card.
Admit card.
But our admit card does not have a photograph, but compartmental it is there.
Wow.
The police left it, I picked it up, I kept it myself.
Hmm.
Some other documents also I kept with myself. 2006, I received some information that he is in Imphal.
Oh.
Myself and my brother-in-law, we went there. We virtually kidnapped him. Virtually. Because 10 o'clock, Imphal at that point of time, 2006, Lordship will not even find street dogs out there.
Right.
It was so horrible. We took him from his home. But I had a client who was an IPS officer. I had did a few cases for him. So we took him there. Then he was handed over to the local police and he was brought back to trial.
Hmm.
But ultimately, the court below gave him a death penalty. It was modified. It became life imprisonment here. But the fun is now. He's released. He's out.
Shortening of sentence 428,
He's out.
433. Yeah, that happens.
So
For that matters,
I have a first.
Poolan Devi, she was involved in n number of cases. She was released in 9 years.
So that Lordship, in fact, after that, I refused to take up criminal cases.
Yeah, you are justified, right? Yeah, absolutely right. Okay, we'll carry on tomorrow.
Lordship.
Tomorrow you focus your attention on how you will be able to link these funds, assuming that we hold that the funds were defaulted. So that is not the subject matter of trial in this case. How do you